501, I appear for the uh, appellants or the SLP petitioners.
Yeah,
Because I understand that the matters for directions. So this,
that's right.
yes, so
The
the
pleadings are complete.
yes, the pleadings are complete. This is the,
Right, shortly, the issue, what is the issue?
You've not
Yes.
yet been formulated, Malad. I think some
So
agreed issues will have to be formulated.
So there is one more angle, my lord, if I can assist your lord, appearing for your order passed by your lordships, my lord, which your lordships would find order dated 6th September 2017.
That's right.
Now, this honorable court was pleased to record that we have received a draft bill and that will be presented. You know, that was the status then. But since the list came at a very late midnight, my lord, I could not take instructions. But from the media reports, my lord, and an interview, my lord, I find that that bill is withdrawn and a new bill would be introduced, my lord, in the next session of parliament.
No, but why is it referred to the council?
yes, so Manoj, I'll just indicate there
Why
was.
is the matter before the?
Yeah, I'll just tell your lordships. So the issue over here was.
There a
there-
conflict between benches?
No, there's a messaging service called WhatsApp. A messaging service called WhatsApp. Now that as far as WhatsApp is concerned, the company itself was taken over at one point of time by Facebook.
That's right.
Subsequent to that, there was a change in the privacy policy. Now, that is the subject matter of challenge in the High Court, and that was the subject matter of challenge before the High Court.
Yes.
The High Court has rendered a decision. When the matter came up here, a bench presided over by Chief Justice Kehar felt that the issues were so important that he said, and there is an order recording so, that this would be referred to or should be placed before a constitution bench. There were no questions at that point of time which were formulated in terms of the reference because the issues overall were regarded as great moment and of great importance. Thereafter, there have been a series of orders in this case and a series of hearings in this case where the issue of maintainability, etc., has been debated, and previous orders will reflect that several counsel have addressed the court on maintainability, what the issue should be, whether it should be taken up by 5 judges, etc. Subsequently, there's a very major development which has occurred. The major development which has occurred is that now there is a cleavage in the WhatsApp privacy policy, which is being applied, say, I'm illustrating, to Europeans versus that which is applied here in India. And the degree, and we place that on record, by the way, by way of affidavits and further applications, etc. And what we find is that the standards which apply to a WhatsApp user in the European Union are much higher, and the degree of protection and privacy which is enjoyed by them is of a higher order. Those options are not available here in India. So one of our thrust arguments is that, look, until such time as the bill or whatever, the act finally takes shape, because we've seen this saga going on, and then the government, well within its rights, has withdrawn the bill. There was a committee, a parliamentary committee report, and they want to bring it, they want to align it. That's what the statement says. They want to align it now with the recommendations, etc. Even subsequent to a bill being introduced, it's possible that it may be referred to a parliamentary committee, etc. We don't go, that's all in the realm of speculation. But the issue today, which is a live issue, is that Indian users, according to us, ought not to be disadvantaged qua users in global jurisdictions, because according to our understanding, privacy now is, apart from being a human right and now recognized by our court as a fundamental right, has global implications. And if it's a universal human right, and if you are able to persuade your lordships that it is a universal human right, then as far as global corporations are concerned, they of course have to comply with local laws. But absent a local law, they have to adopt a golden mean or a golden standard, which we will place before you in terms of what is being. So this is very much a live issue, number one. It's an issue which we'll assist your lordships to on whenever date is convenient. And we will place matters both with respect to maintainability as well as. But what was suggested by the Solicitor General, which was correct, what he reflects said was correct, that at one point of time, even after hearings were held, because the committee was constituted, etc., the matter was deferred. But now that is several years earlier.
Was it being heard by a constitution?
No,
Yes, it was being heard by a constitution. So you'll find a series of orders after the first order,
Once
which was
in May.
heard by a constitution bench on several days. It's not just one day.
No, no,
It
no.
was heard.
only one day.
Your Lordship,
It doesn't matter.
orders.
Doesn't matter.
Please see, let us start 18th April 2017, please. Please have a look at the order of 18th April 2017.
It was heard. I mean, that.
Yes, then
That's
27th.
important. It doesn't matter what.
Well, 1 or 5 may
It
not
was
be.
heard earlier, that's all.
Yes, it's heard, and it was heard on maintainability, etc. And the court records dozens of, I mean, not dozens, I'm sorry, a series of counsel who've been heard on both sides. So my request today, to keep it short, is that please, I mean, whatever, subject to the convenience of the court and the other side, please place this on some date when we can assist the court. In my estimation, we will take less than 2 sessions.
That's only one thing. I'm sorry. Now, so far as the petitioner,
Facebook, what's
So I'm appearing for
one,
WhatsApp.
one thing for the government, I may say.
Facebook.
But so far as the petitioner's contention is concerned, but it is the stand of the government that Indian citizens cannot be discriminated against as against the other consumers of the same WhatsApp. But my lord, my respectful submission is that the government is alive to this situation, and the preparation and my lord, the making of a bill, my lord, is already ongoing, and it needs a legislative response rather than, my lord, a judicial intervention. And if your lordships can consider waiting till, my lord, the legislation is put in place, your lordships would have the benefit of that legislation also, because many of the concerns of the petitioner may be taken care of.
Well, as may I,
When
may I?
will that happen, because can we keep on it?
Well, as-
Lord, yes, since it
2017
was-
was going on
Yeah,
for
we are-
5 years.
my lord, since it was listed yesterday, very late, my lord, the matters were listed.
It was being heard earlier also.
Yes,
So that was some 2 years, 3 years back.
That's right.
No,
So if the legislature was keen to have a legislation, it could have brought the legislation. I mean,
No, there was a,
either we keep on endlessly putting it on.
no, what I'm submitting is
We
there
have
was a
to
there was a legislation, a new bill was prepared. That new bill, my lord, for good reasons, my lord, is now withdrawn, and another bill is under preparation, my lord. Since the matter came up late night, I could not gather the instructions, what time it will take.
Well, as may-
That's my answer.
May I, Manas, just respond? I'm appearing for WhatsApp. My learned friend is for Facebook. Now, Manas, this litigation is not WhatsApp centric. Because if you talk, my learned friend has made it WhatsApp centric. If you talk of privacy policy, it applies across the board to all platforms. Maybe Facebook, maybe Google, Twitter, every platform it will apply. So it has implications not for WhatsApp. It has implications throughout the world on all social platforms. That's number one, Manas. And all intermediaries, it has implications. That's number one. Number two, Manas, the High Court in this matter decided that the writ does not lie. Well, that's an issue that your lordships will decide at the appropriate time. Third, my learned friend talked about the European law. Manas, European law is a unique law applicable to Europe. For the rest of the world, Manas, WhatsApp follows laws of all other jurisdictions in the rest of the world, whether it's Australia, Canada, United States, and Japan. For all those jurisdictions, the present law is applicable. So my learned friend is now saying, because it is discriminatory for Europeans, we should follow the European standard, and we should not follow the US, the Australian, the Canadian, the Japanese standard. Well, that's something that your lordships will have to decide.
Mr. Sibal,
See, our job.
sorry, I'm
No,
sorry.
no, go ahead.
Go ahead. Mr. Sibal, are we correct in understanding that you have different standards? Obviously, you have now said so.
Yes.
Indian WhatsApp users are the highest in the world. Is that correct?
that is correct.
Yes.
So the advantage and disadvantage for the largest group of users is what is perceived here, apart from the maintainability aspect that you have pointed out.
No. The issue is not that, Malas, whether they are the largest user or not.
No.
It will depend on jurisdiction, Malas. The point is, it depends on jurisdiction.
We'll
The
discuss.
point that I'm making is, Malas, it ultimately depends on the law framed by Parliament. If the European Parliament frames the law, Malas, the jurisdictions will have to follow that. If the US Senate frames a law, that will have to be followed. If Australia frames, so what my learned friend is saying to your lordships is the following: that they and Malas, kindly don't look at it from the point of view of one aspect also, Malas.
No, I'm sure there are many.
Now kindly look at it from this point of view. This has global repercussions. If we are the largest users,
True.
it has global repercussions.
And
If we are the largest users, it depends on the kind of investment that this country is going to get into. If you have a law that restricts through a judicial determination certain policies, Manas, you may not get the investment. So it has commercial implications. It has investment implications. It has free speech implications. It has privacy implications, and it has implications that we should. Now there should be a judicial dicta that we should follow the European law and not laws all over.
one is not saying that, but the
No, but at the
commercial
same time-
exploitation of data.
At the same,
That's right. So, Manas, there's a commercial aspect to it. So, Manas, there are.
at the same time,
It's not-
if you go through the judgment of the Delhi High Court,
Yes.
direction was given, actually.
Yes.
A direction was given. At page number 15,
Yes.
you can see an order was issued that the users who opt to remain in WhatsApp are concerned. And up to 25/9/2016, that shall not be shared with the.
Yes, we have complied with that.
complied.
Complied.
So it
We have
cannot be
complied
said
with
that
that.
that was, it cannot be said that that was not entertained or.
No, we've complied.
If it could not have been maintained, where is the question of issuing
No,
such an
that's I'm saying High Court decided. I'm not, Malas,
High Court?
I'm
High
not
Court
saying,
was
Malas, that your lordships will be inhibited by that technicality.
High
I'm
Court
saying
decided.
issues of far-reaching importance.
There are two choices.
Yes.
In the light of the observation made, the submission made by the solicitor. One is to consider posting it in January. Yes. Which means this will give the legislature ample time to bring in a law. What are we here trying to, is it establishing a point or securing the rights of the users? Now, if the legislature is going to come forward with a comprehensive law, which may be a solution to all the problems,
Yes, sir.
we need not be breaking our heads to, establish the point in law as such. If there is no likelihood of, if that's, I think, a reasonable time we are giving. We are putting it, say, somewhere in the second week of January. The other is to put it at the earliest, which can be in the second week of November, and proceed to hear the matter.
So may I respond to that? So Manoj, first and foremost, I don't have a problem if the matter is fixed in the second week of January, but it ought to be, I can only request, it ought to be on the understanding that there will be a final hearing on that particular
Absolutely.
date. Because it can't be that in January, then we are again for
No,
direction just
no.
for another 3 months.
Either there is
Yes.
a law or
Yes, either there is a law, yes.
or we will begin hearing.
Yes,
Or there
because
That's what you're
the
saying.
burden of our song is also until a law, what should be the norm required? No, that is ultimately, because how can we prevent a parliament from, or whoever, whichever the appropriate legislature is, from making a law, and that can always be amended because there will be an element of experimentation. So I have no problem with 15 January, but I will only request that then let it be in 15 January, whatever date or thereabouts, fixed for final hearing. We will file our written arguments before that.
All pleadings
Yes,
to be
yes.
completed, we'll go on with the case.
Yes, I agree.
But my stand is clear. My stand is clear. Howsoever big a multinational is, if you are operating in India, you have to comply with the laws of India, and you have to treat Indian
Who said no?
citizens with equal degree of privacy which you are treating others.
That's true.
But the difficulty is, I'm not making it WhatsApp centric. It should be citizen centric.
That's correct.
And no, it's not correct. Many of the directions of the central government are flouted. Many of the legal directions under statutory regime are flouted. We are arguing one matter, Lord, filed by one intermediary. I'll not name. Mr. Datar is appearing in Karnataka High Court. So, Lord, they may not feel that since we have a global presence and we have kind of a
All right. We learn it.
My lords, I have been the corrected
My lords,
mine is a writ petition where pleadings are not complete. It's also a correlated issue of data localization, where our private data should be stored within the norms of this country and be made available to regulators and courts as and when called upon for. There's no law to that regard. All the information pertains to us, WhatsApps, whatever, is all being stored outside India. So therefore, the compliance with courts, orders, and regulators is pure voluntary in nature by them. So my prayer is, Milos, in terms of informational privacy as recognized, Milos, by the bench of this court, the data should be stored in India and made available to them.
That's
My lord,
Issue pertains to us.
my lord, we have had an improvement into.
Oh, you are here.
Sorry.
We're searching for you. Yes.
Sorry, my lord, we filed an improvement intervention application that had been accepted by my lord in 2017. So Vishwanathan had appeared on our behalf in my lordship, seeing the orders. We had made detailed arguments.
Who's that?
Mr.
Who was-
Vishwanathan for Internet Freedom Foundation.
Huh?
Internet Freedom Foundation, my lord, it's a digital rights organization. So my lord, we had filed our petition is also on our intervention application is also on record. My lord, we had also filed an application for directions. Given the 2021 privacy policy. However, despite many times trying to get the matter listed, the matter was never listed. Our IA was never listed. If my lords, I can just request my lords to issue notice in our IA. I understand that pleadings in their IA are complete. So my lords, we don't even need pleadings to be complete, but just so that we can argue on the 2021 application, my lords can just take note of our intervention application number.
What do you say? Does anyone have any objection to her?
No, they'll assist.
I think court
they
the
can
first-
always assist the court.
She can always assist the court. My request to your lordship, let the matter come up and at that time, whatever request is made, your
We
lordship
will
will
bear
consider
that
it.
in mind. We'll give you
Yeah,
all
yes,
the
yes.
notice.
My lords, we just note this.
Yes, all the parties, I mean,
Yeah.
will intervene so that
There's no issue.
not impleading.
Yes, yes.
No issue.
Some kind of, personal.
Fair enough, fair enough.
So there are two dates that I find. Let's read the calendar. I think 10th and 17th of January are Tuesdays.
10th of January.
17th.
Yeah, whichever date which your lordship for
17th.
final disposal.
Why 10th of January is inconvenient?
Well, there'll be lot of miscellaneous.
There'll be a lot of holidays, bro.
Holidays in
Sometimes
between.
there'll be a lot of holidays.
That's why I said.
All right,
I
17th,
don't mind 10th.
17th January.
Come.
Yeah, Pongal.
Yes,
On that day, it's understood.
yes, it'll be for final disposal.
It is for final disposal.
And your lordship may indicate some date, say a week
The
before,
first week would
where
be a
short
miscellaneous.
notes of submissions can be filed.
But who will actually, all these constitution-based matters, we would like to have a common convenience
That we'll do, Manoj.
so that you'll have to get together and put it together. So
No, we'll ask Brinda to take it up.
Huh?
We'll coordinate
But
with
with Mr. Kanu Agarwal and
Brinda.
Brinda,
Somebody from the,
Lordship may note, we want to record Kanu Agarwal and Brinda Bandari will coordinate to make a convenience.
that's right.
Lordship
So
will
it
documents and then
needs
they
to be
can
completed
compile.
by matter. So reply has been filed. In the
In all matters, they have to complete whatever.
Yes.
matter-
I don't know, his thing is that he wants all the data to be localized in India. That's
Whatever, pleadings to be completed by end December,
We will insist that reading should be completed
by 15 December.
15 December,
Yeah.
exactly.
Before the vacation.
We will
Yeah,
have
so 1 month.
clear idea.
Yes, yes,
And then somebody will actually put together a
Yes.
common
We'll do
convenience
that.
for you.
yes.
We'll do that.
So we don't have to look to many volumes. That
reflecting all views, Manoj, so that pagination is continuing.
Who will undertake that task?
My
So
lord,
that's Kanu Agarwal and Brinda Bandari.
Kanu.
Huh?
I'll do it with Mr. Agarwal.
Just give the name of.
Kanu Agarwal, Manoj, KANU.
Having heard, no, first of all, so when this matter came up, started, Solicitor General. Sapita, the matter came up suddenly, was yesterday night. It's pointed out, this is a case where Parliament had introduced the bill initially. But for good reasons, it was withdrawn. It is further is sufficient that the stand of the government of India is
There was a draft. It was
It's not introduced, Manoj, if I remember correctly.
It was.
It
It was
was
introduced.
went to a
It
parliamentary
was
committee.
introduced in December
But
2019.
I'm not aware, so it may not be possible for me to make an accurate
Look,
statement.
my lord, it was introduced in December 2019. It got referred to the joint parliamentary.
If my learned friend says it must be.
It was.
We have
tabled.
I'm relying
We have
upon
a
my lord, the
withdrawal.
last
It was
interview.
tabled, it went to the parliamentary standing committee, then it was not introduced formally.
introduced. So it was tabled.
Tabled. Manoj.
Tabled it.
As the bill was tabled,
And withdrawn.
bracket, you may just say.
Later withdrawn.
Council for WhatsApp.
That's correct.
But your Lordship may say
Would
proposed.
correct it by pointing out that though tabled and referred to the committee, it was not
Formally,
introduced as
Yes,
such.
it was
Bracket
subsequently
process.
withdrawn.
and then subsequently withdrawn.
Withdrawn, not, it was all the
The first bill was withdrawn.
Yeah.
It was called the.
However, the other solicitor would point out that Parliament is mulling, bringing in a new law, which should address the concerns of the parties. It is a definite stand. But the policy of the government of India is that the users of WhatsApp and other platforms in India should not suffer discrimination in comparison to the users of these platforms anywhere else in the world.
Lordship may not say
May
that
not say
because
that.
We are saying it because we are not putting it into that.
Yes, yes, please.
No, I'm not. That is my.
No, please record it.
no, Lordship.
Record it because that is his standard. That's why you are not going to be affected.
But why say WhatsApp, Malad? Just say all the users, Malad.
Just
So then
all
you're also saying that
intermediaries.
WhatsApp, you know, why?
All interviews.
So otherwise,
I don't
Malad,
say what
it has also.
all intermediaries. All
No,
intermediaries.
as far as European Union are concerned, 27 countries
Don't
have
worry,
different
that's-
platforms.
don't worry, nothing is going to happen.
Out of 213 nations, only
You can
27
continue to do merrily what you're doing. Nobody is stopping you in the meantime. Okay. Sri Shyam Diwan had a senior counsel for, you are appearing for the petition.
Yes.
So the petitioner would submit that while it may be all right, if some time is granted for the Union of India in its decision to introduce a law and make a law, the matter being adjourned, it should be on the understanding that when it is listed on the next occasion, it will be taken up a final hearing unless it be the impact of the legislation overwhelms the issues which are covers every issue which falls for consideration in this case. But we are inclined to adjourn this matter, taking note of the submission made by the Learned Solicitor General to the 17th of January. This is case on the 17th of January for final hearing. By the 15th of December 2022, pleadings in all these cases shall be complete.
My lord's family request, we have an IA 11372, which is impugning the current 2021 policy direction. My lord, we should notice on that so that the pleadings can get
Not
complete.
WhatsApp centric, I don't know why.
But I
you-
think.
No, this is again
Allowed all
All these things you can argue.
No, intervention is allowed.
Allowed.
This is a application for directions, my lord. Just
To what direction for what?
my lords, which is on the 2021
It's against
policy.
It's
WhatsApp.
only against WhatsApp. It's only against WhatsApp's new privacy
That's right.
policy.
What do you want? You want
This
them
notice to be issued.
Not
my
by
lords.
virtue of an application, they want to challenge the new policy. Not.
I don't understand.
My lords will see the last order. My lords will see the last order of 15th February
don't think you
2021, my
should
lord.
be doing that.
But not by virtue of an SLP, the new policy has been challenged in SLP. I mean, that only can't be done.
So, I mean, what is going to be the effect
legal
of
issues
not
will be
passing that order?
Okay, my lords.
It's going to be a legal issue finally.
That's
It's
right.
it's not going to go on facts as such.
That's right.
And there we will have the assistance of Sham.
Pleadings would not be of much relevance.
No, wherever pleadings have to be completed.
It will have to be, but-
We are giving you ample time. But on that day, if it is not there, I mean.
Yes, yes.
Nothing concrete doesn't have to be proceed to the hearing.
Yes.
You understand? So and so, just take the name.
Mr. Kanu Agarwal and Mr. Prabhas Bajaj will provide that
Will
convenience.
provide that common convenience volume containing
Documents relied upon by
documents
all
relied upon-
respective parties.
The documents relied upon and also the contentions of all the parties.
No, but that's documents, no, that's just compilation will be documents and then,
It's only the document.
yeah, only the
Only
documents.
the documents, all right? Only the document.
Common compilation of documents
Common
on
combination of documents.
or before 10th of January.
But let's kindly add the name of Shashank Mishra from our side on the
Yes, certainly.
convenience
That's
compilation.
fine.
Yes.
So we're three of us, so that's just not Kanu Agarwal, but Shashank Mishra as well as Vrindavan.
You can begin by completely owning up the financial aspect of it. So,
No problem at all.
so we'll put together.
Shashank Mishra.
The name.
Common compilation containing all the documents relied upon by all the parties before the 10th of January 2023. Okay?
Yeah.
That's
Deeply obliged.
And if you would like a short note of submissions on or before 10th of January by the respective party. If you would like a written note, not necessarily we'll.
Not necessarily.
That's in both
Grateful,
cases,
thank you.
the connected matter also.
Looking at the face of the lawyers, I got a bit confused. Who is the face of amongst Dr. Sibal, Yogi?
Well, it's all of us
Who is the
together.
face of Facebook?
No, all of us together. All of us together.
We have our leader in Mr. Sybil, but we are all there to assist your lordship. Lordship not making like a Ravan with 10
You
faces.
are not replying to Devin's question. Who is the face amongst all?
Grateful.
Yes.
It's a very important but very simple, short issue. This is that is the appointment of the election commission. Today, my lord, it's only the prime minister who decides. We are saying that in accordance with the reports of at least 4 commissions and committees appointed by the government, the selection should not be just with the government because it's supposed to be a neutral body, and the selection should be by a committee. Our suggestion and the suggestion of several committees has been that same kind of committee which selects the chief of CBI, that is the prime minister, leader of opposition, and the chief justice. They should together recommend the selection of the election commissioner. And on this, my lord, as I said, there are a large number of reports of several commissions which have recommended this or something similar. And the constitution merely says that selection will be by the president till such time, appointment will be by the president till such time that a law is made in this behalf. Dr. Ambedkar in his Constituent
Let's not argue, but this needs hearing. Kindly fix the
I'm
date.
just pointing out what the issue is. He had said that it would not be fair or proper to leave the selection only to the government. But thereafter, my lord, they felt that the law will soon be made to provide for a neutral selection committee. But unfortunately, it suits every government which has come thereafter to continue with the same system and leave it only to the government. So we are just seeking that direction in accordance with the directions that were given in Vinit Narayan, Prakash Singh, etc. That till such time that a law is made, let the selection be by this kind of neutral committee. That's the suggestion. So it won't take much time. I will not take more.
There's a second petition which has 3 supplementary issues which are raised. One regarding the protection that is given to the election commissioners apart from the CAC. That's one aspect. Second is having a devoted secretariat for the election commission. And the third is about its draw being on the consolidated fund. Now, all of these issues are essentially both Mr. Bhushan's petition and.
There are 2 petitions. There are 2 petitions.
Yes, there are 2 petitions, 502 and 502.
I must inform your lordship that there is also a third petition which was filed recently. And Justice Rastogi had issued notice in that. Similar issue, same issue. Except there we are also seeking an interim order. So your lordship did not connect it with this one. And your lordship has issued notice and fixed it. It should be coming up soon after notice. But this matter will decide the fate of all the other matters so far as this legal issue is concerned. It's not a very long issue.
We'll list it on 9th of November. That's all.
Yes. That would be fine.
That's all that we have to do.
Yes.
Lord, only one thing, my lord.
Readings are complete.
Pleadings are complete.
I'm Lord, slightly on a different point. I can't have any objection, my lord. But 9th of November, my lord, there is already one constitution bench concerning, my lord, that the Delhi government will be the controlling authority for the civil services also, my lord. November and December being, my lord, very few days left, my lord. There are already 3 or 4 constitution benches fixed, my lord, because Court 4 is also taking up, my lord, matters of the constitution bench.
So
Court
the
3
government has many law officers.
No,
very good law
but
officers. So
he has to be nasty, but I ignore him always, this time also. Lord, therefore, my lord, kindly fix a date, my lord. My learned friend, Mr. Balbir Singh is here, my lord, but we are also appearing there. So,
But let it not be put off too long.
yes, my lord.
it's a very urgent.
Perhaps I just need to accommodate you till the 15th of November. that week, because this also has to go on.
Yes, certainly, my lord, certainly.
That's fine.
We'll put it on the 15th of November.
That's
Very
fine.
good, very good.
We'll accommodate you, don't worry, I mean, that's
My lord, 15th of
15th or 16th, either.
My lord, 15th of November is, my lord, again, but both of us are there, my lord, in that article, section 319, Sukhbir Singh Khera. But this is genuine difficulty, my lord. I am,
We have no aid, but then we have to also go on with
Yes,
the
certainly.
it's allotted to us.
certainly.
So we can't be,
No, no, I am not, my lord, for a second.
In fact, the Attorney General has been directed to assist in this matter.
so that there may not be a problem for you.
Thank you, Gopal. I read the orders.
Sorry, I'm just saying
No, you
he's
should be
convenient.
sorry for what you said,
No, I'm
but
saying he's
but
convenient.
any date, my lord, other than 15th, that's all.
So 16, there's no difficulty. 16th of November, this is case of the 16th of
Lord,
November for hearing.
my lord, 15th would
16th of November.
can I request? Only a minute, only a minute.
Can I just say one thing? I'm just saying because a specific direction for the AG to assist, his convenience may be sought. That's all I'm saying.
The
Not
AG
trying to undermine anything.
That's
Just saying. Because he's not represented here.
No, the learned,
You're projecting your convenience.
No, I'm not.
Lord, my learned,
Both of you are projecting. We are saying that we have taken a call. I think
Absolutely,
that decision
absolutely.
should be left to-
obviously, my lord, that's ultimate.
Let me make this.
I must tell Mr. Gopal Shankar
I'm
Narayan,
not seeking
the
learned
learned,
in the least.
learned
Any date
AG,
your lordships choose,
Eh,
fine with me.
learned AG has assigned Mr. Balbir Singh and
give a common compilation.
That will.
Lord,
Yeah,
instead
common
of,
compilation.
my lord,
You make,
instead
you
of
make it-
16,
You will make a compilation.
Lord, can I request for a day's accommodation?
Yes,
Lord,
sir.
instead of 60.
Huh?
My lord, the CB court 4 is on 15th. Lord, it might spill over. Would your lordships consider 70
Oh, I mean, that's all.
instead of 70?
I'm fine
That's
with
not a problem.
any date. Whatever.
I am not
17th.
going to take more than 1 hour to argue this.
That's
matter.
right.
It's a very crisp,
So
clean.
17th of November, that is it.
Please.
Correct. Who will make a common?
Mr. Upadhyay will make it.
Huh?
Mr. Ashwini Upadhyay will make it.
He's appearing in this as a.
He is.
Well, Mr. Shyam Gopal, my learned friend, Mr.
Let
Balbir
me
Singh.
make it, let me make it, I'll make it.
Yes.
I'll make it. It's all right.
But
Sham Bhushan.
Lord, everyone will have to coordinate with his office. My lord, his office is busy. Mr. Colleague of Mr. Balbir Singh, Mr. Shyam Gopal,
No,
and Mr. Ashwini Upadhyay. May do.
that's whoever wants to make it. I thought that.
I am happy with anybody making it. I am just saying, I am happy to do it myself, but otherwise, let whoever wants to make it, let them make it. I'll give them, in my case,
That's
the
right.
document is there.
Kindly fix the person who will make the common.
Mr. Shyam Gopal and Mr. Ashwini Upadhyay.
Let a young person do it. That's the.
He
Well,
certainly,
Gopal-
Mr. Gopal.
All of us qualify, my lord, to be in that category.
Gopal and Gopal, Shankar Narayan. Somebody from your office, you can.
I'll do that. I'll have that.
Will put together a common convenience body containing all the documents which both sides will be relying on before on or by the 1st of November.
Yes.
The time one whole month is there,
That's
Very
fine, that's fine.
That's fine.
so that we'll have the opportunity. Yes.
Very well.
Grateful.
I'm appearing for the petitioners in one of the cases. There's a match of cases.
Accommodating all the.
Yes.
But see,
The Jallikattu.
Jallikattu has now got here because of Tamil Nadu, Maharashtra and Karnataka because of 3 sets of laws.
How does it come before the constitution?
There's an order passed by the specific, the past, kindly just see.
So
Second
broadly,
February.
how are the lines drawn? I mean, who's on which side, what?
Well, that's-
We on the petitioner side, we say that the amendments pursuant to Jallikat are unconstitutional. They are saying they are valid. That's the only
That is
issue.
by the Tamil Nadu.
both,
That's
both legislative,
I'm appearing for
legislative
Tamil Nadu.
competence
That's
and
as well.
fundamental right.
Both.
And of course, contrary to this court's judgments and today.
So you state of Tamil Nadu, right?
Yes, I'm appearing for the state.
Union is not Union is not.
Union, my lord,
Union is not-
my lord, I am appearing for the state of Maharashtra. My lord. I am briefed by the Maharashtra.
But may I just say this?
But if Union is a party, some of us will appear.
Here also the pleadings are complete.
No, there's one thing which will have to be done. There are specific questions framed on 2nd of February 2008, if my lord draws and has a look at the order.
Yeah.
The lordship will find this order relates to reference systems. That is relatable to the Tamil Nadu legislation. So now there are subsequent petitions filed. Those questions will just need that extent of modification in relation to the other legislation. Does your lordship have it?
Yes, we have it.
My lord says,
It's the Tamil Nadu Amendment Act. If we get to
I'm
that.
not,
Yes.
if my lord is kind enough to see para 3 after hearing the petitioners and respondents for some time, we are of the view that the writ petitions need to be authoritatively decided by a constitution bench of 5 learned judges, as the writ petitions involve substantial questions relating to the interpretation of the constitution. The questions which require reference to a bench of 5 learned judges, apart from other questions raised, are set out below. Is the Tamil Nadu Amendment Act referable in fifth and substance to entry 17 basically of the 7th schedule, or does it further and perpetuate cruelty to animals? Can it therefore be said to be a measure of prevention of cruelty to animals? Is it colorable legislation which does not relate to any entry in the state list or entry 17 of concurrent list? The Tamil Nadu Amendment Act states that it is to preserve the cultural heritage of the state of Tamil Nadu. Can the impugned Tamil Nadu Amendment Act be said to be part of the cultural heritage of the people of state of Tamil Nadu so as to receive the protection of Article 29 of the Constitution? Is the Tamil Nadu Amendment Act in fifth and substance to ensure the survival and well-being of native breed of wolves? Is the Act in fifth and substance relatable to Article 48 of the Constitution? Does the Tamil Nadu Act go contrary to Article 51A(c) and 51A(h), and could it be said therefore to be unreasonable and violative of 14 and 21 of the Constitution? Is the impugned Tamil Nadu Act directly contrary to the judgment in Nagaraj and the review judgment dated 16 November 2016 in the court said this, and whether defects pointed out in the aforesaid judgment could have been overcome by the Tamil Nadu legislature by enacting the impugned Tamil Nadu Act? There is not similarly a Karnataka legislation of 20th February 2018, which is the sport of Kambala.
Yes.
Now, Lord,
Maharashtra.
that has been impugned in, amongst others, WP Civil number 1152 of 2018.
So what are the issues we are?
That will apply. That will apply.
Very material.
Very material, yes.
Just,
So we just give a date. and we-
yes, yes. I just want to mention, Manoj, that the Tamil Nadu legislation was referred to the president for the assent, Manoj, that the Union of India, the president gave assent. I just wanted to mention that.
304B.
On our side, I think if your lordship is
Yes,
saying
thank you.
that
The
date will
president
be
has
ready
sent
by
it
the
to the
9th
particular
of August, that
legislation.
was mentioned, 9th November, if it is convenient to the court.
That may be a little.
That could be a
early.
date which your
We
lordship.
should have it in after the other matter, Manoj, the WhatsApp matter.
After WhatsApp, man.
Yes,
Wait.
because after 17th November, Manoj, the holidays will be.
Lord, if your lordship sees the calendar,
Calendar, Manoj, there are so many other matters.
Matter is in.
Can you?
Have it.
Because of the submission made by the.
Yes, your lordship may have it early January then, Manoj, or whatever.
Why not November?
Yes, yes,
No,
9th November.
Well, January already the thing will be too late.
Yeah,
They
yeah.
will start Jallikat.
Absolutely. Either way.
You have to have it in November.
Whatever, Manoj, I have no objection to the date.
November may be better.
I would.
also requested earlier, just few minutes back, 9th November is the.
That's right. We have taken that, factored that in. That's why we put it on that.
And after 17th November, any
We
date.
can put it on the 22nd or 23rd.
Yes, 22nd November.
That's much.
That will be, that's it.
Right.
But it's as a matter of housekeeping,
You are appearing for?
not for the petitioners in their petition number 1193 of 2017.
What will be your contention?
That, my lord, that the act in question is is unconstitutional.
On legislative competency.
Legislative competence as the assent to the president, which is alleged to have been obtained, is also, that has also been notwithstanding that the act is liable to be declared as unconstitutional.
You consider Article 30 petition.
Yes, yes.
Yes, all these are Article 30 petition, as I see. There's an earlier judgment.
Petition, you go into question the legislative competence.
You can, my lord, provided there is also a question of violation of part.
Exactly. Otherwise, ordinarily.
Otherwise,
That is so.
not in Article 32, If it questions only the legislative competence, your lordships have said that it cannot be entertained.
Cannot be entertained.
But when there is a violation of part 3.
You're doing both.
Yes.
Yes.
All right.
I just want to.
So readings are complete.
Yes.
That's one thing I want
Your lordships like. Sorry, your lordship.
How many items are there?
I think there are 5 or 6.
May suggest one thing. If your lordships just have the calendar, instead of last week of November, if it can be first week of December.
That's too late.
That'll be too late, then we'll have
We hardly have
Yes.
2 weeks.
2 weeks. Yes.
Hardly have 2 weeks up in that.
Not in any case.
December.
Last week will be miscellaneous week, so in any case.
Carry this be close to the closing.
And it will take, we will definitely be taking a while. We'll take a few sessions to present our case.
22nd November, I think we'll.
So in this matter, you can give there's some kind of a written note as well.
All right.
Yes, we'll have them ready.
Would your lordships kindly.
Idea, you get the slice.
Yes,
Yes.
Well,
Broadly, they are crystallized, my lord, but
there are 5 petitions.
I think there are
15.
What is that?
1-5.
Okay, they are filed by.
Lord, all animal rights groups. Animal rights groups.
Different groups, Lord, what we.
All over the country.
May I make a suggestion? We'll
You are
categorize.
appearing for?
Lord, I'm appearing, Lord, in 503.5, 503.6 and 503.12. So, Lord, I'm appearing for Compassion Unlimited and Peter, Lord, in 2 matters. What we will do for your lordship is we'll categorize them as to which relate to which legislation, put them in order.
So who will do that?
Lord, I'll
No,
ask
the
my-
housekeeping
I'm happy
part
to
of
do
it,
the
will not
housekeeping.
Miss Mauleki, who has been
Sorry, can do
associated
this,
with
sorry.
this.
And Mr. Dharmadhikari Manoj can be.
No.
Siddharth Dharmadhikari.
I'm saying that the writ petition filed by her,
I'll ask my.
we'll ask them to do it because they have been associated
So
with
that,
the
in one volume, you get
Yes.
everything.
We'll have-
We'll have a convenient
With
compilation.
continuation of physics.
This Preeta Iyer is there.
Yes,
Requested.
I'm only saying that in the writ petition filed. Yes,
And readings are all complete.
Pleadings are complete, but your lordship may just give, say, 2 weeks from today. A
Anything
week
that
from
has to
today to complete. There is a new.
All right. List is.
No, I'm sorry, Judge.
On the 23rd of November,
23rd.
for final hearing, number 1. Within a period of 2 weeks from today, the pleadings shall be made complete in all the matters.
Wednesday you want it?
2. A common convenience compilation shall be prepared,
Very soon.
cooperating with reference to all the 15 repetitions.
Writ petition.
By
Miss Preeta is.
By Miss.
Yes, Iyer.
Miss Preeta is.
By Miss Preeta
Preeta
Iyer. Lord, we'll give the name.
And my lord, Mr. Dharmadhikari on our side. My lord. Siddharth Dharmadhikari.
And
And
Mr. Kumana.
The
Mr. Kumana.
Other welfare board, which is the main statutory authority, they would want to do it, is it?
Millard will be doing it.
Let them do it. They are the neutral.
No,
party.
but that's right, but
There
let's be so there's nothing.
All are neutral. For compilation, there is.
what
In a
difference?
compilation, what?
That's what we have already.
You do it together with them.
If it was a vegetarian, it will be a neutral party.
Lord, in fact,
They are a
in
statutory
fact, Lord, on the lighter side, they don't take it otherwise. They are all meat-eating animal welfare groups.
Meat eating, I'm sorry.
Except Mr. Diwan, except Mr.
No, I thought fish was not meat.
No, I'm sorry, I'm sorry.
Sorry, fish is not meat. Please don't mistake fish.
So on the lighter side,
Maybe so, but.
No,
in a
but
matter like
I
this,
contest.
the sensitive comment.
That's all right.
that's on the lighter side.
So now, individual submissions, we'll have to make.
We will make a week before that.
That cannot be, a combination.
No, that'll be separate.
We'll make it 2 weeks.
Lordship, I say.
The petitioners will make available their written notes not exceeding 5 pages,
Yes.
containing a gist of the issues, the contentions and contentions, and the case law, which they rely on.
Yes.
On or before the 7th of November.
Yes.
Much
That
obliged.
will be, you get ample time.
Yes, of course.
7th
14th would be better because your lordship said 22nd is the 22nd is the
23rd,
14th.
Because if you get it before,
Well, 1 week before Malaj, your lordship.
why? Because you've got a month already.
Lordships have to read 60 briefs every day.
That's right, that's right. We have to do it, all of it.
Towards that direction.
We are
That
very thankful.
leadings-
Lawyers
leadings-
our brief.
We have already said that. We
Very
know
good,
it's
very great, very
completed.
good, very good.
Coordinate with everybody.
Obliged.
2 weeks, put it in 3 weeks, because of our coming week. Holidays, so instead of
3 weeks can be, yes, make
3
it
weeks.
3 weeks in place of 2 weeks for completing the readings.
grateful.
Fine, fine.
Obliged.
Grateful, Lord.
504. What is 504?
I appear in 504. So this is a matter which was first filed in 2005 as a writ petition. And this is what was popularly called living will or
Euthanasia.
not euthanasia. Euthanasia is assisted dying.
That's right.
So this is an advanced directive. No, this is not euthanasia. Euthanasia was that Shanbag, Anuradha Shanbag, where she was lying comatose for 28 years and finally in one.
Assisted dying.
No, this is not as. But I'll explain what it's an interesting point. Lord, all of us have to ultimately meet our maker. Now, to give an example using the singular pronoun, I can today, this is a matter regarding advanced directive or what is called living will. But before Lordship sees that, I'll just give a broad outline of what this is. Today, I can make a declaration stating that if I happen to be in a coma or if I'm not in a chance of recovery or I'm brain dead, etc., then please don't have any intervention, no life support system. I'd like to die with dignity rather than suffer the eating of so many things. Also, the family is put to the avoiding embarrassment of spending huge amounts, etc. So I do it. So this is a concept accepted in different parts of the country. So finally, we placed this matter before the court. And what happened was the court issued directions, which ultimately turned out to be unworkable because after the direction, we spoke to a number of doctors. Now, basically, what the Constitution Bench has said is this. Suppose tomorrow I sign an advance directive. So today, let's say on the Dasara holidays, I have to go before a judicial magistrate first class. I must say, I, Arvind Datar, etc., make a declaration that in the event of my, sorry,
Don't use your.
I XYZ, sorry. My apologies. I XYZ make a declaration. I have to make it before the judicial magistrate first class that don't have any life support system. Now the XYZ's time ultimately comes maybe 10 years later, 11 years later. That time, what the court says is, suppose he's admitted, let's say, in Apollo Hospital, Chennai. Then a team of doctors in Apollo Hospital must certify that there is no hope of recovery. This person is brain dead or he's not able to live. That's first stage one. Now, then the matter is referred to the collector. Then the collector has to constitute another board of independent doctors who will take a second opinion. After the second opinion, it has to again go to a judicial magistrate first class who has to personally come to the hospital where Mr. XYZ is and certify that it can be withdrawn. But we took these directions. I personally discussed the matter with 2-3 leading doctors from Chennai, and I also spoke to 2 doctors from Bombay. They said this is unworkable. You can't have a system. Suppose a person, let's say, is in Apollo Hospital. He's an 85-year-old man. He has signed a living will that his life support system should be taken away. Now, you can't expect Apollo to constitute a committee. They can. But then that matter has to refer to the collector of Chennai. The collector of Chennai then constitutes this independent medical board. That medical board has a second opinion. That is then again taken to the judicial magistrate. He must come to Apollo Hospital, see Mr. XYZ and say he's now life support can be withdrawn. So what we have done is, each of the directions issued by the Honorable Supreme Court, on the basis of discussion with doctors, we have suggested how it should be amended. That's the thing. But in fact, what happened was the court said that
So who are the respondents in your case?
Union of India.
Only.
But they filed a counter saying that these suggestions are not suitable. I thought that they
Next of kin has that choice. Unfortunate choice.
very difficult choice.
Very difficult.
Very difficult choice.
It's available with the next of kin. And any person can refuse treatment. As of now, as the law stands now.
But this basically
If
what
somebody is very unwell and he chooses not to go to hospital or to any doctor, no one can compel him or her to go. That is the law. What stands now.
there's no there's a
You are
practice.
talking about a situation where he is under treatment, but medically there is no possibility of his going back to normal life or going back to life.
Not one suggestion. He is in a state where he's incapable of taking a decision.
Incapable of taking a decision.
rather-
Right now, the family members take.
Yes.
So you want him to take that decision in advance.
So XYZ today says, so let's say XYZ is let's say 70 years old. Now he's going to make a will. He's going to make a will bequeathing his property. He also makes a declaration there that in the event of my coming to a situation where I have to be put on life support system, the Lordship is right. We have all relatives who say, please don't do all this. I would like to go peacefully. I don't want too many surgeries, etc. So I can make a statement before the judicial magistrate first class that we are willing to accept. If they want a safeguard, we can have it. But this multiple committees of doctors, reference to collector.
One committee can't be a one committee.
One committee,
Doctors examine it, then the magistrate and all.
The collector.
Can't one committee at the one go take a decision? And if suppose he is not capable in taking a decision, so can't be the first kin to that person.
But Lordship suggestion excellent. One committee of doctors plus the kin can also.
Consolidated. Yes, one committee.
No, this is, I have not
You
seen
can't keep the line pending for long because you don't know at what point of time he might collapse. So he has to take a decision at the first go. One committee.
the earliest.
The earliest. One committee constituting all magistrates independence of the committee and the government also keep a check over it. And the first kin to that person.
Son,
Let's
daughter,
take
whatever,
one.
yeah.
One kin, whatever. The magistrate takes a decision.
The magistrate will be difficult because let's say a place like
whatever it possible.
a judicial magistrate first class. Now let's say Delhi or it's Madras. Where is it? Egmore? Is it this or Bombay? So is it Powai or is it Andheri or is it Bandra? Who knows? It's very difficult.
In the judgment dated 9/3/2018, A to E, 5 directions have been given. All directions are there in that judgment.
Yes, which I have tabulated.
That is in page number 13.
Yes. So we just wanted to see if Lordship is willing
This is actually an application
to modify the.
matter to modify.
Yes. Yes.
Usual application, but now it has made its way to the constitution bench because
No,
it was
because
decided by the
Constitution bench. No, the only thing is,
What the ambit-
having speaking to the doctors, as my Lord Justice Rastogi suggested, why have multiple committees? But let it not be that person's. See, let somebody responsible take a decision.
What is the stand of the government?
I have not, my lord, had the benefit of going through the affidavit, but forget the affidavit. This is a human problem, my lord. And, my lord, people do face such problem. And we also know, my lord, all of us, many people who would say that if I meet this kind of a fate where I am almost going, don't insert things in my body, etc., etc. So, my lord, this needs examination. The only concern, my lord, which is again my concern, I have not discussed with the government, but the concern was, my lord, even during euthanasia, etc., that in our society there are circumstances where old people who are our elders and their blessing should continue forever for us, sometimes in some families become unwanted, and this may not be misused by the family member. So there has to be some cushion, my lord, so that whatever he says is true. As a matter of fact, my lord, I know of a very senior, eminent lawyer, my lord, eminent advocate in Gujarat. He was detected with cancer. He said, I don't wish to be treated. We were like children to him. His contemporaries also went. We also went to persuade him. And his answer was, now it's his call. I don't want him to tell me that you have to be dragged. I want to tell him that I came gracefully the moment you called. I don't want to trouble my family. I don't want to trouble this body because with treatment, maybe I live 3-4 years more, but I don't want to be dragged. So there are several reasons for it. A person would not like to subject himself to such agony and subject the family to agony. So I can sit with the government and there's some way can be found. No, this
Also
cannot.
essentially domain of legislature,
Correct.
possibly.
No, this is like a 142 Vishaka situation till the government makes a situation.
Till the legislation falls in.
No, when I spoke to doctors in Bombay and Madras also, many families can be financially ruined because the person is in coma, ICU endlessly, nobody is taking a decision, then what happens?
But that family can take the decision.
You know,
That
the,
point of
see, my
time.
lord, the difficulty
When
are
to pull out, when to pull out
The ventilator.
ventilator, that rests.
No, this
the-
guideline doesn't say
my
so.
lord, the harsh reality I can tell your lordships. And again, my lord, leaving the brief aside, as a human problem, I'm saying this. But I have seen cases where the doctors say that a day or two on ventilation will survive the person. But the ventilation charges are very high. And there was, my lord, a fight amongst brothers who will share them. And it was decided that better not to put him on a ventilator. And some of our, my lord, friends and group, my lord, we collected the money and the man survived. My lord, leaving it to the next of the kin might be counterproductive also. There has to be, my lord, some way out so that this is not misused. And the wish of the person not to be subjected to any undignified way of forced survival is, my lord, respect.
Both survival and also forced departure.
Yes. Yeah, both will have to be balanced.
Yes.
So,
But I know
can we
cases
have
where
it on
people
the
have-
23rd, because we have
Yes,
put
yes,
that other matter
yes.
on 23rd.
Yeah, they know. Lord,
So.
But this can be, I'll in the meanwhile.
tell the learned solicitor, Lord, there is an order passed on 22/1/2020. Unfortunately, it came just before COVID and then everything got
You
derailed.
know, what I'll do is, what I
This is
suggest
what
is,
meeting is undertaking
Courtmaster.
to have a look at it.
what I'm suggesting is, not, forget the order.
Joint meeting. There's an order of the court.
Okay, okay. I was suggesting that. I didn't know this.
Just to see that.
Otherwise, I'll call the officers. I'll invite Mr.
22/1/2020.
Datar also
Yes.
at my place. I'll call the officers also. We'll have a joint meeting. But maybe they have some concerns, some apprehensions which can be
So it
taken
will
care
be
of.
better because you know.
Yes, yes.
the hearing
This is not a
should
matter.
should not be a matter. This is not adversary.
It cannot be adversary. It's
Cannot be adversary.
My friend is right. They could be a case of a misuse. But they could many cases where it would be great relief.
correct.
Great relief.
Third of-
The earlier case, Mr.
Earlier
Bhushan
case
said
we
it'll get
said-
over faster. Let's speak in
That's right. We just put it on that day. For some reason that doesn't happen.
24th.
So.
Mr. Bhushan's matter, your lordships have kept it on the
23rd. This will be after that.
23rd. So immediately.
immediately after Jallikattu.
Exactly. So, whatever is listed on 23rd, this on 23rd. Just say nothing.
And Lord, I've just given the guidelines issued by the court. What is the problem after discussing with doctors and what could be the modified? Lordship may just think of some safeguard. My Lord may also, your Lordship may come up with some new idea also. We don't know. Your Lordship also may come with some thoughts because all of it is a problem which affects all of us.
And we have seen experiences on either way, as my learned friend is right, that benefits are more, misuse may be few and far between, but even one misuse would be a murder, virtually.
Yes, yes.
It would be.
Just for getting in the middle.
Mr. Datar,
Yes, Lord.
I'm just reminded, you said ideas. There's a very interesting film, I should say, and the title of the film was Whose Life Is It Anyway?
Anyway, yes, yes.
You might have seen it, that sculptor who was confined to bed. I think it would be an interesting film to see.
In the vacation.
You have not seen it in the context of the debate that we have. Whose life is it anyway?
And Lordship, there's a recent
No, there was a-
there's a Switzerland has assisted, Lordship mentioned assisted dying. Switzerland has assisted dying.
Yes.
So an Australian who was 103 years old. He went there and he said, I want to hear my favorite music for the last time, and then they administer the.
Even the Jainas,
But we are not
because that's the subject matter in this court, therefore I will not elaborate much. But Jains have, my lord, the system of Santhara. That is, my lord, the highest form of detachment from the body.
That is something different.
That's something different, no, not comparable, my lord. And Bertrand Russell, my lord, apropos, my lords, there is a beautiful article written by him, Right to Commit Suicide. My lord, he also says, it's my life. How are you concerned with? If I don't like my watch, I might even as well throw it in the ocean. Why can't I do that with my life? That's the theme of his article. One may agree, one may not agree, but very well put.
Lord, in fact, an old judge of the Madras High Court said this is one case where the offence is not punishable, but the attempt to commit the offence is
Offense is right. Yeah, that is right.
That's it. But the constitutionality has been upheld.
Yes. In fact, there's another question, full bench of Madras High
And
Court.
many of these cases of suicide can be really put down to mental health issues.
Yes, yeah, very true.
A
Very
lot of people die by suicide because they reach a stage where if they are properly counseled,
They could have.
they could be brought back.
There are some helplines now
Yes, yes.
where you can
Everywhere,
immediately dial the
everywhere.
number. Helplines are there. But Lordship is right. Young people,
Oh, yes.
mid 30s, 40s.
They know, and that again, my lord, maybe I may not find, my lord, much takers of this view. That's because of, my lord, the family shrinking.
Absolutely.
Because if I am in depression,
Yes.
my brother,
Nobody
my
can
father,
talk with-
there is somebody who will
And
push
sometimes
my.
the system work very well.
Now a two member, 3 member family, there are no friends, only virtual friends. I have, for example, a person has 5,000 friends online.
WhatsApp friends.
WhatsApp friends. There is no his neighbor also to talk to. These are, my lord, the issues.
Lord, in fact, let's just say in a lighter vein that HUF is only in the Income Tax Act now, my lord.
That's correct. Practically, it is only income.
It is.
All right.
Grateful.
My lord, the Lordship may say, the order says have a joint meeting. My friend can give a date immediately after Dasra holidays, my Lordship.
We the year for that we may not trouble the court. We'll coordinate.
I'm not putting it down.
You are always welcome. Anytime I'll call the officers on that day.
All right. So what is this? 505?
I just give a brief outline as to how the matter has travelled to the Lordship. So it's,
Arbitrator.
it's the question, my lords, whether an arbitration agreement in a contract which is required to be stamped and registered is not registered and stamped, whether that arbitration clause can survive. Now, my lords, the matter travels like this. My lords, we filed a suit. Work order was issued by respondent to me, unregistered document, unstamped document. In that, there was an arbitration clause. We filed a suit because it involved invocation of my bank guarantee. The trial court granted me ad interim injunction. They filed a Section 8 application. Relying on SMS T and Ms. Garwale, we said that this arbitration clause cannot work. Trial court rejected the application. Against that, a civil revision was filed, kept pending for 2 years, withdrawn, then a writ was filed. We objected that Section 8 order is appealable under Section 37. A writ is not maintainable. The High Court clause by the impugned order said it's not an absolute bar. In peculiar facts, we go by and we filed a review, dismissed. We came to your lordships, and our only argument was that Section 37 is a remedy. 1. 2. SMST and Galwale say that since the contract is unstamped, the arbitration clause is non-existent. It cannot be worked out. With utmost respect, the matter was closed for judgment in November. Vidya Dhrolia affirming Garwale and SMS came in December. And the judgment clause, which makes reference, is in January. It holds SMST overruled because Garwale is affirmed by Vidya Dhrolia, therefore Garwale is now referred to your lordships. That is how it is. We never argued all this.
January,
I have no difficulty.
who is appealing against it?
Because there has been a subsequent development. The direction was to impound the contract and I was supposed to pay. Document impounded, I have paid. My bank guarantee has been in cash, 3.5 crores. And now I have invoked an arbitration clause saying that please give me back my money.
But who is appealing as respondent? Nobody.
It was contested on first minutes. They appeared.
There is nobody. We may have to consider appointing an amicus. That's why if you don't do it today.
There was a caveat.
We were just appearing for the bank was not concerned with the arbitration.
In fact, let's.
For that day, there is nobody appearing. There's no lawyer. Nobody is there. You're not contesting.
Looks, they were there in the first round.
There are two.
Was a caveat there.
Charu Ambani and Sanjay Kapoor.
That's right. There was somebody.
There was, no, they filed a caveat. It was
They
after.
were fighting KBA. Now.
After recovery, because they've got the money, so perhaps.
Leave granted. Here you can put it debt on reserve.
That is 23rd November, and Vidya Zola came on the 14th of December. And we never had any opportunity of making any suggestions on Vidya Zola.
I did not brought this actual notice of the court that some judgments are pronounced by the after the judgment are reserved in this case.
Milos,
would I make an application to just
with utmost respect, I tried to file a review application. It was not accepted in the registry. Number one,
Not
number
review.
two. No. Then I filed an application for modification of the judgment, modification of the order. Not our case.
Regard to the nature of the issues which fall for our constitution in this matter. And also there is none appearing today for the contesting respondent.
Respondent one.
We have considered that the amicus must be appointed to assist the court. Facts of this case, we appoint Sri Gaurav Banerjee.
I will supply.
Civil counsel.
Which I will
He is a senior.
Civil counsel. To assist the court in this matter. The registry will forward the papers to the amicus. And this is case 15th of what day is that we put at imagine that 17th January.
Look, may I have one request? There's an IA which I have.
How long will you take? You must tell us how, depending on how long it takes for you to convince us.
Because according to me, the whole judgment is premised on things that we never argued. Neither of us argued.
No, but once the matter has come to us, we have to examine and decide the issue.
We will,
one for all.
I'll take not more than half an hour because my IA contains all the material, the relevant provisions of the Maharashtra.
Judgments are there.
Everything. Only a compilation perhaps of judgments that I'll take.
As regards registered, unregistered documents also, this principle of impounding, there are two lines of authorities. One is that court cannot look at it.
That's
the
what
other view is that
impound and then paid
Impound
duty and then
yes.
this direction was issued. Our document was
Anyway,
impounded.
so there are two line of authorities in those for immovable property also.
Was never argued. Nothing of this was argued.
I think that half day is sufficient.
More than sufficient. More than sufficient. More than sufficient.
We put it on the 6th of December.
6th December? May I have just one more request? There's an IA which is IA number 24652 of 21, which was lodged for modification, but ultimately it was said that this is akin to a review, dismissed. It has all the material. That IA may be taken up and permission.
Make it a part of a compilation.
I will do that. I will do that. So, Miller's 2 weeks to file the compilation.
Petitioner is granted 2 weeks available to the court a compilation containing
the contents of IA number 24652 of 21
yes,
and all relevant judgments of your lordship.
containing this and the issues involved.
The issue is only.
You just put a note, because
The issue is, the question is crystallized already by the court referring the order.
all the elements, and containing all the elements.
Yeah.
So, compilation containing the contents of IA number,
24652 of 21 and plus the compilation of judgments,
and all the
relevant judgments.
relevant elements.
Give us three lawyers, name of three lawyers who are very active in arbitration, young lawyers.
Mr. Data.
Data?
No, Mr.
No, not Data.
Mr. Balbir Singh.
We want three young lawyers. Not Balbir Singh is not young lawyer. We want three young lawyers into this who are into very active in arbitration. Mr. Banerjee, who are those young lawyers according to you who are very active in arbitration?
Oh, there are quite a few.
You can't select even just now. Give the name.
And he's saying he will select the name.
I'll get hold of it.
Not for your assistance, for our assistance.
My lord,
We want our assistance. That lawyer.
there are quite a few of them, my lord.
This is also there.
Give us names.
I'll give a few names.
6 December.
6 is.
Very well. My delegate.
Now, this has some importance for the armed forces. What has happened is, my lord, there was an application for clarification which was filed on behalf of the Union of India, pursuant to, my lord, the judgment in Joseph Shine. Joseph Shine, as your lordships know, strikes down adultery. And broadly, my lords, the grounds were that this was essentially the patriarchal aspect of that provision, which treated women as chattel. Now, my lord, be that as it may, we're not directly concerned with Joseph Shine because that was decided on a different. My lord, we are really concerned with what amounts to discipline or indiscipline in the army or the armed forces generally, and what is unbecoming conduct. Because we have our own, my lord, the armed forces would have their own code of conduct. And therefore, my lords, if what has happened, let me just indicate as to what has occasioned this.
Finding it in the form of a clarification.
My lord, what happened was this was a clarification because what happened was this, my lords. There were officers who were charged for unbecoming conduct on the ground that while my lords, that they were having illicit
Feeling the
relationship.
affection or something, the expression used is.
My lord, illicit relationship, my lord, you may call it an extramarital affair or whatever, my lord, unbecoming conduct. We call it unbecoming conduct or, my lord, indiscipline. So what amounts to that? Now, when, my lord, an officer is serving out there in the field and his family is stationed in the, my lord, family accommodation away from the field, and another officer, my lord, enters into, it may be consensual in nature, but therefore, my lord, can we not take action? What has happened is that the AFT took a view in some cases that it must be quashed because of Joseph Shine. So, my lord, this would certainly create some instability within our ranks because, my lord, ultimately we have to be able to, my lord, inspire confidence in the officer who goes to serve in the field. And, my lord,
You're saying that they can be charged for misconduct.
Misconduct, indiscipline, unbecoming conduct, and, my lords, because adultery has very different patriarchal, my lord, connotations under 497. Now, here under this, my lords, our action we can even take against a female officer. There is nothing unequal or it's completely gender neutral. But so this is the issue, my lords, and therefore, my lords, this has been put before a
So
constitution.
which part of the judgment
Yes.
of Joseph Shine's actually creates a problem for you?
My lord, simply because what has happened
What is it that you're seeking to
My
clarify?
lord, we are seeking to clarify that the Joseph Shine judgment striking down section 497 will not come in the way of the armed forces taking action for under certain provisions, my lord, under our respective acts, including the Army Act.
Does it preclude you from doing it? Does the
My lord,
judgment
what has
foresee-
happened is the AFT has taken such a view.
But then should you not independently challenge that? I mean, instead of
No, we have
clarification.
We have challenged it, but my lords, it requires some, because my lord, they are using the Constitution bench judgment in Joseph Shine.
Say the Constitution bench is either right or wrong.
Right.
If it is wrong, you have a remedy of review.
No, my lord, we are not saying it is wrong because it said nothing in respect of the army.
That's right, exactly. Therefore, if you say it is wrong in individual cases, if you have challenged it,
We have.
you have challenged it.
We have, my lord,
There-
and the question has been left open. What has happened in one of those judgments, we have
You
it.
can always pursue that, saying that Joseph Shine cannot stand in the way of your, taking action against somebody who's.
My lord, this has specifically been referred to a constitution bench.
It is said the criminality about adultery
Right, right,
has been done away with.
right, right.
So that doesn't mean that the
Service
conduct is that does not mean that the conduct cannot be treated as misconduct.
Absolutely, which is
By
what
an
we are
employer.
saying. Correct, correct.
Is there any taboo against that?
Because under section 63 and section 45, you are referring to
Absolutely.
those.
We are relying on that. In fact, we had charged one of these officers under 45 and the AFT took a view, and this is coming up in multiple cases. Yes,
Any kind of a misconduct defined
yes.
has to be examined independently.
That's exactly what we are saying, my
Oh,
lord.
how this judgment will come in your way in taking a
Lord,
decision.
this is what unfortunately the AFT has been doing.
That you can challenge.
Lord, we have
What happened to
challenged
that?
in one of those decisions, my lord, the court, this court,
Yes, relying on this, this was your.
my lord, because my lord, there he had been acquitted, so that was taken care of. But as far as the question on section 63 is concerned, my lord, the issue was left open. So, my lords, what has happened is that this has been referred to your lordships because Joseph Shine is a constitution bench judgment. So, 3-judge bench has referred to. So, my lord may just decide the issue whenever convenient. It won't take very
Just 1 minute.
Yes.
Immoral act. Any immoral
Lord,
act
we don't use a.
is not a criminality.
Yes.
May not be a
Exactly,
criminality.
madam.
May I submit?
Exactly the issue, madam. Should they be treated as a criminal or just a simple misconduct? That is the only issue, madam.
May I submit?
Lordship has taken away the criminality part from the adultery provision, madam.
That's correct.
But they are still treating them as a criminal, madam. That is the only concern.
No,
That is the whole point. If it is a.
a ban may not be. It might be slightly different to say that you should not be punished because the woman cannot be treated as a chattel.
Yes.
And dragged to the court and things like that. In the uniformed services,
Yes.
where discipline is of the paramount importance,
Yes.
the aberrant conduct, at least as it is understood to be, conduct which involves actually shaking up the life of the officers, because everybody is ultimately dependent on family as a unit for society. And the integrity of the family is primarily based on the faithfulness that each spouse expects of the other. So if this is going to shake up, discipline, the life, the even tone of somebody's life, and the armed forces must have, some kind of, they should have some kind of assurance that they take action. How can you cite Joseph Shine and say that, it cannot be?
May I submit, Willis? I am
Can I
appearing
make
for
one
It's not exactly desirable conduct. See, when you say that it should not be treated as criminality, and it's not a criminal offense, the court is actually, in this particular case, actually taken a value judgment of its own, substituted that for that the legislature with reference to fundamental rights and said it is violative of fundamental rights. Okay, that's fine.
Yes.
But the employer says, you take a case of a private employer, forget about the state. Supposing the private employer has its own view, he says that we will not permit this, and we treat this as misconduct. Treating it as an item of misconduct, action is taken. Can you produce Joseph Shane and say, no, you can't?
Not at all,
ma'am.
not at all.
Shall I make a very short
If a private employer can be permitted to do that, then why not stay?
Willis, may I just make one?
I was appearing for Joseph Shine. Shall I make a very short submission, Lord, in answer to your Lordship's query?
Yeah.
I was for the petitioner in Joseph Shine.
We know that.
I am just making a very short answer to that. As your Lordships were observing, there is nothing for a clarification at any rate. What I am respectfully placing, Lord, as your Lordships were observing, but in Joseph Shine, we only, Lord, challenged the constitutionality of 497 of the IPC and 198(2) of the Criminal Procedure Code. These three sections, or this half a dozen sections were in the Army Act, in the Navy Act, and in the Air Force Act, were not the subject matter of Joseph Shine. So what essentially happens is, it is something the respondent center cannot have a case which the petitioner in Joseph Shine did not have. We cannot now expand the scope of the repetition in a clarification application. That's what I am respectfully pointing out, my lord, as your lordships were observing. Now, my lord, as your lordships were saying, if at all in a particular case, but a defense in the light of Joseph Shine was taken, but it is then for the center or for the authority to prosecute, to pursue that particular case. But one case, in United States Court of Appeal, Perez versus State of Roseville, but was a case where a departmental action was taken for the alleged bad conduct. Then the United States Court of Appeal decided in Perez versus State of Roseville, where one will have to find out the nexus between the alleged act and his official duty. Likewise, but in our country also, unless and until it is agitated in a particular given case, this cannot be decided now. But the Joseph Shine decided only 498, and the Lords may also appreciate one fact. Neither of these sections.
You take the case where there is an enumerated item entering into an illicit relationship with somebody else.
Yes.
And a live-in relationship with another man's wife.
Yes.
Amounts to misconduct.
Yes.
Correct. Can you
Yes.
apply Joseph Shine and say?
No, it cannot be. That's what I am also saying. Joseph Shine did not decide that.
That's exactly what you're saying.
May I just make one submission?
Joseph Shine did not decide that. It is beyond the scope of Joseph Shine.
It is a simple
Can I
question.
just make one submission?
Yes.
Section 45 and 63 of the Army Act are very clear. If at all any person subject to the Army, Navy or Air Force Act behaves in any manner which is unbecoming of his conduct as an Army officer or Navy officer, Air Force officer, he is likely to be, he is absolutely liable to be punished for misconduct under the 45 and 63. 63 says any officer or any member of the armed forces subject to this act, if at all behaves in a manner prejudicial to Army discipline.
Probably the solicitor, additional solicitor, what people is concerned about.
My lords.
Some of the observations in Joseph Shine.
My lords.
This perhaps tends to sort of give the impression.
My lords.
That you will be intruding into the liberty and the freedom of the individual.
Make
a choice.
My lords.
But freedom appears to be to have an illicit relationship.
Very well.
You cannot go there.
Let's do that, my lords. May I just say this, my lord?
One more thing.
This, my lord. Yes.
Now, in this, suppose is for this sanction, of course, in the light of the decision, he cannot be penalized.
Yes, my lord.
But at the same time, the question is whether he can be subjected to disciplinary procedures. In terms of the
That is what we are trying to answer. As your lordship Justice Ravi Kumar was observing, but what I would respectfully answer to that, Lord may kindly appreciate. But none of these sections.
He cannot be penalized under the provisions of the IPC.
That is different.
But certainly under the provisions of the Army Act, he can be penalized.
That goes without saying. That's what I am also saying. What I am
Madam, I would request you to just wait a minute, please. Just a minute. Lord, what we are saying is that because there is such a large number of cases which are coming up before the AFT has taken a view. Now, my lord, if we keep appealing in individual cases, which of course we have to do, in the meantime, my lord, there are so many disciplinary actions which are being stalled, and it is very dispiriting, my lords, for the officer who is serving in the field. So, my lord, that kind of confidence we have to give our officers.
There, the solution is,
yes,
in one case,
yes,
the matter is decided in one of those cases where the party is also heard, and this court, if you are going to have a final decision, this court is
I think, my lord, we are requesting this court because it has already been reported.
Clarification.
My lord,
we think that.
my lords, for once and for all, it will take care of the problem. It won't take very long, and your lordships may have to go on.
In one of those matters where you are quoting an order against.
Right.
You can challenge it, right? that particular decision with the person also on the party array. So he will have to say, I don't know whether he's here in your clarification.
No, he's not
here. So we are invited to make a clarification in the absence of the person who's going to be affected.
No, Milord, may I put it this way?
Problem.
Milord, we can certainly implead those parties. No, I'm just suggesting this, Milords, because ultimately, Milords, it requires clarification and this
How
corporate.
are you here? How are you here? You are here because there is an AFT order.
Right.
Which takes a view that the employee whom you have charged with absconding is protected by Joseph Shine. We take it that's your problem.
Yes.
Still.
Yes.
That order can be independently challenged. Which is why we began by saying whether you say that Joseph Shine is in any way wrong. You say you have no quarrel with Joseph Shine. You say Joseph Shine is fine.
Milord, because that is the way we are reading Joseph Shine.
That's right,
Which
exactly.
is, yes, that is the way we are reading Joseph
Once you
Shine.
accept that Joseph Shine is
Right.
right, this clarification business I think should not be sorted to.
Milord,
it's better that you carry the matter. You will have a final
please
discussion.
consider-
With the other person also on the party array. You will have a discussion.
Milord, just give me a minute. Let me just confirm.
That will be better.
Then can I just make one submission? Instead of tinkering with Joseph Shine, what my lord said is absolutely the correct way of going about it, because the person involved in one of my clients in fact has suffered 3 months rigorous imprisonment for allegedly having an extramarital affair with somebody else, some unmarried woman. However, my lord, it doesn't fall under the ingredients at all of Joseph Shine or adultery. But what happens is Joseph Shine by itself, my lord, has secured in dignity and equality to women, not making them subservient to a husband or his consent on that footing. However, Millers, to say that what they are trying to make out probably is that culling out or classifying army wives, their submission in the application is quite shocking. They say that army wives are living separately in in separated family quarters, and their husbands, their officers are at the border. So the husband should not have insecurity in their minds that their families are dealing with undesirable actions. Well, this is an affront to any army wife. In fact, me being one.
No, it's not applicable to army wives. No.
Absolutely. And that the
I
context.
may also point out, I may also point out more explicitly, but a review petition was filed.
Let her make the submission.
Well, because if my lords just reads the contents of this application, they are actually the prayer may be very.
Why do you say it's an affront to the?
Because they just read one paragraph, my lords.
You can tell us in your own words.
Yes, sir. What they say is to ensure that all personnel perform their duties without unnecessary concern for their families. There is a system where frequent visits to families living away from their spouses by officers, JCOs, is a regular feature. In view of the aforesaid judgment, there will be always a concern in the minds of the army personnel who are operating far away from their families under challenging conditions about the family indulging in untoward activity. Well, is this paragraph and also some.
See, it's only concerned with the army officer involved.
So,
if the concerned lady or male
absolutely
is having a relationship with a person who is not an army personnel,
that's right, my lords.
that is not prohibited.
Absolutely. So what happens is, where do they draw the line? If an army wife.
An officer gives a complaint.
Yes, your question, please.
Why do the officer gives a complaint that he's having an affair with somebody? Or the No, you're talking about the adultery being committed by the wife, isn't it? Wife of the
Lord, in this particular case, yes, that we are talking about, yes, we are talking with another officer, with another officer. In this case.
No, in the event the lady is the officer and
Both, it's gender neutral. Our action will be absolutely gender neutral in that sense. So, my lords, I just want to say that please do consider, because your lordships are taking up these matters, because this may, what has happened is, and that's why, my lord, the 3-judge bench referred it to the Constitution bench, because,
is there anything in the judgment
right,
which stands in the way of your, treating this
Right.
kind of conduct
yes.
as misconduct? Is there anything in the judgment which precludes you from taking that?
My lord, because, my lord,
For example, supposing the judgment says in some part
yes.
that it's perfectly all right for a married woman to have an affair, perfectly all right, then it can't be misconduct.
My lord, very frankly, my lord, because our list came very, very late at night and I was informed in the morning, I have not had the chance to comb through Joseph Shine in such detail.
Unless you do that
So,
and point
yes,
that out.
yes.
Nothing is stated, my lord, in the clarification application either.
No, so my lord, what has happened is
One
the
point I
three-judge
may make.
bench has advisedly, my lord, put this
Why don't you,
before 5
then
judges.
go through the judgment?
Yes, I'll go through it in
And
more
then
detail.
if there is anything
One point I may make. One point I may make. You know, none of these sections.
There's no need to spend more time on it. Give a date, that's all.
Yes, I think fair enough, fair enough.
And we have told you our view.
I've
There is nothing in the judgment which stands in the way. You will be advised to withdraw the application
and then go directly.
and go and challenge those individual orders where you have a problem.
Right.
If we will definitely reserve the liberty. You have that.
Right. So your lordship may keep it on another date. I'll get back to your lordships on this, because we do not also want a situation where, my lord, before this court, it comes up before a smaller bench, which it will. And, my lord, that bench would be
That's
then
right,
bound by
that's
5 judges. Yes.
Badri, one thing more.
Yes.
Any immoral conduct
Yes.
of an officer in his official duties or as an
He would have read this, had those orders. But to the best of my knowledge, my lords, there is no such matter. In fact, yesterday, one of my matter was dismissed and held that misconduct because of adultery, and his dismissal.
That's why we say that a case-to-case examination is the only way out. A case-to-case examination cannot be done in a clarification application without the parties. It's a totally different thing.
Both of you
One point I mean.
both of you counsel are aware of the pain, deep pain that adultery creates in a family. We have held so many sessions as judges in the high courts, in habeas corpus jurisdiction, and we have seen how families are torn asunder with adultery. I mean, this is a thought, we thought, we should keep to ourselves, but we are just telling you, don't treat it in a very lighthearted manner. If you have experience, what happens in a family when adultery takes place?
these are broken.
Completely broken. And children, I recall one incident. There were 2 children. Mother committed adultery, and she filed a habeas corpus. She wanted to interact with the children. They came. They were 13 and 11, I think. They even refused to talk with their mother. I tried my level best. Such a, it really broke my heart on that thing. That's the kind of rancor, that's the kind of hatred, the kind of, even violence as it happens.
And it's still a ground.
That part of it has been taken care of by Joseph Shine itself, and that has been retained as a ground for divorce, even in Joseph Shine.
That's right. You
We are concerned. We are concerned. None of these sections you Lord make highly appreciate is connected as in excess.
Joseph Shine, that's not based.
My lord, I filed an application for placing certain important documents on record, my lord.
Let me answer on that.
IA number 121314
First of all, let her see whether she is going to press the application, otherwise.
Right.
Yes.
We can give this.
Lord, may I kindly fix a date for that?
This is a small matter. It shouldn't take.
No, it won't take very long.
We can have it on the 16th, where we have put that matter that this.
16th of your lordship is intending it?
6th of December will I give.
All right, very well.
Yes, 6th of December.
Just
Yes.
would my lord just, I would just.
Including, my lord, the question of maintainability, your lordship may hear on that, my lord, if the sender is not withdrawing it.
Yes.
Because we have serious issues with respect to its maintainability. A review petition was earlier dismissed. It comes, my lord, after the dismissal of the review petition.
I'm only concerned with
Let
the
us see,
armed
let us see, let
forces,
us
my lord.
Just, I would just request them to supply, just to provide us with the orders with AFT, because I, to my best of my
You
knowledge.
request, why do you need a court's order for that?
Obliged, grateful.
Grateful.
They were having clash today. Came here, I told to manage.
And Lord, this famous thing, it is said that marriages are made in heaven. It may be so, but this one has turned out to be a hell for sure. The allegations of the counter allegations are indicative of the intense hatred and rancor between
Just see, very interestingly,
them. Any reconciliation is out of the
very
question.
interestingly, when you're reading para 8 on a factual matrix, just read the respondent has only been trying to explain that several serious the products of sick mind and mere figment. He submitted that her children, even the sister and mother of the petitioner, are siding with her in this dispute, that the petitioner alone atoned from the entire family in prosecuting her. If the evidence would be led, all others would stand in the witness box in favor of her, who are relatives of the husband.
Yes, that was her claim. Then, my lord, at page 10, but none of these were subjected to any scrutiny.
Yes.
Page 10, apparative.
Whether you prove or you don't prove, if this is the feeling towards each other,
Yes.
you are right, what is left of it?
So it was an indicator, my lord. It was an indicator that what.
The indicator, there's a case you sent to a mediator, actually. Most times this was not so active. You send it to a mediator that, look, if they stick by these allegations, then what is left in marriage?
Yes. Yes, very, Lord, if I may say, this court appears to have a trend in which they encourage compounding of offences under 490. No, under a different procedure court, it's not a compoundable offence. Now, my lord, I take it that the policy behind that is to see whether things can be settled by the ending of that litigation, where parties have agreed that people settle the dispute. We do not believe that criminal litigation should be initiated in order to settle a dispute. But I can tell you that absent a regime of matrimonial problem, women have no choice. Why? Again, one day that case will come before you. But it's been on trying to find it for a very long time. What is the validity of saying? How does one interpret the Hindu Marriage Act on the question of alimony? What exactly does it mean? Does it mean that you're willing to give equal distribution of property acquired at the marriage? You will see a
Holding the very apart from in the back of the mind, there is loop. So say if he goes into penury, he doesn't earn anything, nothing happens. The wife will make reverse allegation saying all the wealth of the family, everything is owned by him only. So, in absence of probity or issues of evidence, to do some kind of some interest. There is no other option. In the same way as maintenance, you have to look at the income tax return, but you also know that sometimes these are not reflections of, so while even granting internet, there is some value judgment which we have passed or some kind of, where we say no, this man must be, this is his assist broadly in the field, he must be working. go by internet. I've lost my job. I've had on the reverse ladies saying, look, qualified ladies saying, I've given up my job, I don't want to work. Now give me on the basis that I don't want to work. It's also not an acceptable situation. So, social issues.
Well, at the end of the day, it's very difficult to sit in judgment over what goes on inside the home of the marriage. It's very difficult to say you are at fault, or even to evaluate their behavior. So much is a matter of personal perception. That's why it's a this relationship in the realm of the intimate.
You can't say where it began. Very difficult to pinpoint where it began. Maybe our perception, maybe A has done it, but the fact is that B may have said something or done something which may have triggered it off. The trigger continues. Nature is everything is behind. Ultimately, the relationship is broadly behind four corners of the house and the closed door. You're not going to find.
So, Milan, I'll quickly finish with.
But in this Bhagat versus Bhagat, madam, in Bhagat versus Bhagat, the court dissolves the marriage on the ground of cruelty. Have you seen that?
Yes.
In Bhagat versus Bhagat, court records a finding that there is cruelty. And under section 13, the marriage is dissolved.
Yes, my lord, yes. And that is actually something that I would commend for acceptance, my lord, in the sense that you don't really need 142. And that is why the question of consent is totally irrelevant, my lord. It's totally irrelevant. Because at the end of the day, the judge is the arbiter of that dispute. There's always going to be lack of consent, always, invariably. But how do you deal with a situation where there's lack of consent? Ultimately, someone takes a decision.
It's a matter.
Everything is changing to the extent.
Argued in person by reasonably eminent counsel himself in his own case. The Bhagat person.
In the High Court, not here, in the High Court.
In the High Court, it was argued. It's a well-respected lawyer's case and both sides well-respected.
Yes, they do. My lord, but one essential safeguard, and I'll leave it at that. My lord, even this judgment actually, let me tell you, my lord, how I see the issue. There is no time to explain it, but I will put it in a few words. My lord, it is like.
Yes.
My lord, as I see it, and this judgment has glimpses of that argument, and there has been an evolution of the law on how you interpret cruelty at all. And I'm suggesting that we interpret it more and more liberally. It is not cruelty in the sense of torture, etc., etc. No. So, and there is a discussion in this judgment of how the legislature, while amending the Hindu Marriage Act, in 1976, dropped some words such that it's impossible to live with the other party. Those words were dropped. Those words existed in a decree for judicial separation. So the suggestion that I'm making is there's been an evolution of the law relating to how to interpret cruelty as well. The Lordship will see that, my Lord, at panel 14.
The vintage of time of this case was a little different. So society evolves. Today it's gone further on. But even then, while granting on cruelty in para 21, an ultimate paragraph.
Yes, my Lord. And my Lord, I really would like to commend this.
Though it is on the theory that
Para 21, 22 are very important safeguards while granting a decree. May I read them, my Lord, with some emphasis, with all the emphasis at my command. Before parting with it, I think it's necessary to append a clarification. Merely because there are allegations and counter allegations, the decree for divorce cannot follow. Nor is a mere delay in the disposal of divorce proceeding itself a ground. There must be really some extraordinary features to warrant grant of divorce for the basis of pleadings.
Yes.
Not divorce on the ground of irretrievable breakdown.
Okay. And other admitted materials.
Admitted materials. Without a full trial, irretrievable breakdown of marriage is not a ground by itself. A lot of emphasis on the word by itself.
Yes. Now, next sentence is important.
But while scrutinizing the evidence on the record, determine whether the grounds alleged is or are made out and are determining the relief to be granted, the said circumstance can certainly be borne in mind.
That's what I said.
The unusual step as the one taken by us herein can be resorted to only to clear up an insoluble mess. The court finds in the interest of both parties. Now, my lord, I want to just point out 22, the petition for divorce pending in the Delhi High Court is withdrawn to the file of this court and is allowed. The allegations leveled by the petitioner against the wife are held not proved. The honor and character of the respondent wife starts vindicated. My lord, I commend for your lordship this formula for acceptance in cases where your lordships have come to the conclusion that the managers is to be broken down. Because it's also necessary.
So that certainly you take it if we accept the principle and we have been following it and will be followed and in some way expounded by us. That when we are doing so, we are saying that things have not worked out. We are not attributing anything.
Yes,
to
so that
anybody
the decree should not result in any civil or criminal consequences for either party.
Often, where divorce proceedings, how do we do it? There are divorce cases already pending, not a mutual consent, with allegations. Taking the application mutual consent in, that petition shall stand withdrawn. All allegations stand withdrawn. So that first chapter is the whitewash of the allegations. And then the power is exercised.
That can
Very quite a sweet.
the parties agree to file under 13B, to withdraw all allegations and file under 13B.
No, even where we have exercised powers under 142, with one party not consenting, we made sure that the allegations do not stand up.
Yes. That has also happened, my lord, in petitions in this court. There's a wide, my lord, initially the only dispute was whether the 6 months waiting period.
That was a more limited. That's a more
waived.
limited.
That was the only issue the court was considering. Then the court went on to consider whether the 18-month period, you can grant a decree when one of them withdraws, but after 18 months. And those are the type of cases that came to the 142. But there are also cases of the 142 where divorces have been granted without the consent of one of the parties. And your lordship will find in this case there is not even a reference to 142 in Bhagat versus. It's an ordinary matrimonial dispute.
Because the decree was granted
On cruelty.
on one of the specified grounds in the Hindu Marriage Act, but yet in some way covering up the concepts of allegations. See, look at the time period is different, 94 and 2022. Huge social change, 18 years is a huge time for a social
28
change.
years.
However, we have to think of their, I think, ability to do innovative thinking when the society was different in 1990.
Yes, well, also, if your lordships are inclined to take the view that such decrees can be granted, obviously your lordship will put certain indicators in place and certain safeguards.
Yes.
So that's why I call them proxy indicators, that they are actually indicators which are telling you that the marriage is broken down. That's the way to look at it. Now, my lord, I would like to take you to paragraph 22 of my written note to give you the evolution of the law, because this is where I come to the conclusion that irretrievable breakdown is a compendious expression for divorce with fault. Now, my lord, let us look at what happens in other common law jurisdictions. Evolution of the law of irretrievable breakdown of marriage. In the UK, the Divorce Reform Act of 1969 introduced the language. My lord, please note, I'm being very specific with the use of my word. I'm saying it was the language of irretrievable breakdown of marriage in section 1 and 2. But look how it read. After commencement of the act, the sole ground on which a petition for divorce may be presented to the court by either party shall be that the marriage is broken down. Now, subsection 2. The court hearing a petition for divorce shall not hold that the marriage has been broken down irretrievably unless the petitioner satisfies the court of one or two of the following facts: that the respondent has committed adultery and the petitioner finds it intolerable to live with the respondent, that the respondent has behaved in such a way that the petitioner cannot reasonably expect to live, that the respondent has deserted the petitioner for a continuous period of not less than 2 years immediately preceding the presentation, that the parties to the marriage have lived apart for a continuous period of 2 years immediately preceding the presentation of the petition, and the respondent consents to the next remaining granted, that the parties to the marriage have lived apart for a continuous period of at least 5 years immediately preceding the presentation of the petition, A petition for divorce shall be the duty of the court to inquire as far as reasonably can into the facts. Every word is significant, and I would emphasize it. To inquire as far as it's reasonably possible. This raises the question of standard of proof, Lord.
The condition is fairly stringent because if you look at E and E, the parties to the marriage have lived apart for a continuous period of 2 years immediately preceding the presentation of the period of the petition, and the respondent consents to the degree being granted. 1. Number 2, the parties to the marriage have lived apart for a continuous period of at least 5 years immediately preceding the presentation of the petition.
Yes, Lord.
It's fairly stringent.
When you talk about here under this act, irretrievable breakdown of marriage, you can only claim this in the absence of consent after 5 years.
Yes.
That's the little stringent condition.
All those waiting periods are put in the hope that there will be a reconciliation.
And there is another aspect to it. In that society, normally both the spouses are working. They work.
It's true.
It's the normal. It's normal.
Yes, working parents. Working
Indication from the
partners.
transfer petition, let me say, that
Hello. To be honest, this statute has undergone amendments any number of times, and some of these periods have been shortened, not shortened. The reason I put it on record is to show that despite the factors that exist, they use the expression irretrievable breakdown. So there's a lot of significance to that, Lord, that it is a factor to be taken into consideration when certain facts exist. And that's why I repeat, Lord, these are really only pointers to the breakdown.
So you see, in the transfer petitions which we have seen, if I can say, more than 50%, then I would take that as indicators of failures of marriage, because those are coming being lodged, are within the scope of 0 to 3 years marriage. It's a very high percentage of the petitions coming forth before the courts are in early years of marriage. I've seen same day, I've seen few months, I've seen 2 years, but a lot of them are in the range. I would say almost about 50% would be in the range of 0 to 3 years of marriage.
Yes.
So that's why when I looked at 5 years, I thought,
unfortunately, in this country, there are not enough empirical studies. But in the UK, before they passed these laws,
must have done their own.
they commissioned Royal Commission reports on what are the patterns of divorce, what are the reasons, what are the causes, what are the consequences. But what happened here in 2010, we just introduced a bill in Parliament, irretrievable breakdown, without any empirical data as to what are the consequences.
Empirical study we don't do. I've been emphasizing judicially legislative impact studies. Just bring in legislation without any legislative impact studies. It's a great problem. The consequences are felt after the legislation comes.
But, my Lord, with respect, I wish to say that the law in this country is changing. After the passing of the Prevention of Women from Domestic Violence Act, we now recognize non-marital unions as deserving of protection of the law. It says that it's an act which extends not only to married women, it extends also to people who are living in a relationship in the nature of marriage, which was intended to bring in civil unions or of a conjugal nature. And this court has explained what is the meaning of that expression, relationship in the nature of marriage, basically by saying there has to be conjugality. Changing. That is a very major factor, my Lord, that the Lordship will have to make. Indeed, I can make bold inquire into the case so far as reasonably can. What is the meaning of this so far as you reasonably can? Because that's the point beyond which you cannot inquire the case.
Personal.
Yes.
Can't get into this.
Yes.
Relationship.
And look, there is also case law. I can point to it. There was a time when judges were using proof beyond reasonable doubt in matrimonial proceedings in England. In England, it's there, all reported judgments law. Then a court had to step in and say, sorry, matrimonial proceedings are not criminal proceedings. You have to use balance of probabilities to decide. That is why I'm emphasizing this word so far as you reasonably can. So, really, the suggestion that I'm making, which I mean, sooner or later put it into writing, is that give a liberal interpretation to Section 13. Read into it irretrievable breakdown when you see certain proxy indicators. And the nature of the inquiry is on balance of probabilities, perhaps even a more liberal standard than balance of probabilities. I would recommend a standard of perception of the people. That's been done in the case of sexual harassment. That standard is used in law. Because somebody can say, this is my perception that it is sexual harassment, your perception is that it's not.
Yes.
It's a classical case, Manoj, in which perceptions differ. So, Manoj, if you use these three legal tools, a more liberal interpretation, the question of what will do, and a more liberal interpretation of the standard at which evidence will be evaluated, where inter alia, Manoj, your lordship uses the perception parties themselves as a standard of proof of facts and circumstances, and then puts in place certain proxy indicators along with certain safeguards. I don't know whether this proceeding will indicate the precise parameters of financial relief, but that may have to await another case. The safeguard must be there.
We certainly will build into it the concept of a safeguard.
Yes, the safeguard that before any such decree can be. So what I'm saying is, Lord, your lordship may not be able to give a measure of what should be given. For the moment, in my mind, I have only used the standard of living to which the husband is accustomed, which has been used in law. Until we see an amendment that says that matrimonial property should be equally divided. Honestly, my lord, I was looking at the statistics in. There is data of how many divorces are filed every year in the country. So, my lord, can reasonably can.
Some problem is there has to be commission documentation. There has to be some other methodologies to assist the court by producing. Yeah. And suggesting what is to be done. See, I think sometimes everything lands in the lap of the court in a first instance. Instead of the groundwork being done. That's why we request amicus to assist us when we find that there are other assistants not working.
No, my lord. For example, this paragraph 6, I'm sure, has been amended or there is case law. But the purpose of this act, husband and wife shall be treated as living apart unless they're living under the same each other in the same house. So this is no longer the law. Now the law is you can live under the same household and still
live separately.
My lord, in this subsection 5, that what is the meaning of living apart? That means you have to be not in the same household. But this is no longer the law. You can be living in the same household and yet be living apart. Even this court has held that.
Yes.
Now, my lord, I come to to my submission in 2423, from a reading of section 1 and 2 of the Divorce Reform Act 1969, it is apparent that the factors such as adultery behavior in a manner which petitioner cannot be reasonably expected to live with the respondent, desertion or at least 2 years, parties living apart for at least 2 years, apart, not less than 5 years, immediately preceding present, were all taken into consideration while deciding whether the marriage had irretrievably broken down. That's why I said these are proxy indicators. But what you're looking at is there a breakdown? What is happening today under our dispensation is people are not even looking at the issue whether there's a breakdown. It is thus submitted that the above factors are indicated. Now, my lord, come to qualitative in the law. In 1973, UK passed the Matrimonial Causes Act. The Act continues to be enforced till date. However, the Act of 73 was further amended by the Divorce Resolution and Separation Act. But Section 1 and 3 read as follows. Subject to Section 3, either or both the parties of marriage may apply to the court for an order or divorce which dissolves the marriage on the ground that the marriage has broken down. This is not, now you can say it's a no fault theory. Court dealing with the application under subsection must state a statement to be conclusive evidence that the marriage is and make a divorce. Saying that ours is not a system of divorce based on it is a system of divorce based on cause. But the ultimate decree reflects the fact that the decree for divorce. I'm sure that we may not be able to, I may not be able, perhaps I won't be able to persuade you that you should also take a statement. Because that is, at the end of the day, the judicial body looking into it. But here what they've done in England is, they've said no, either or both parties favor.
It's just taken them so many years to come to this stage. Yeah, also it will take time.
I was myself surprised, Lord, because of this confusion in the head, fault and no fault are the same, but they are
The
where you say
distinction
for fault.
is obliterated there, but
Yes, I'm surprised. In between the amendments, but this is the latest amendment now. It is generally believed that changes made in 2022 depart. However, it is submitted that irretrievable breakdown cases mentioned in the original Act of 1973. It is worth noting that irretrievable breakdown of marriage is the consequence of pre-existing causes. That is why, my lord, in the when this court said there was seen as many of which would include adultery, desertion, cruelty, or separation over a continuous period. In other words, I'm saying, well, these are not exhaustive of the issue of it may be noted that the UK Matrimonial Causes Act engaged very clearly that irretrievable marriage and breakdown on account of group are interchangeable, and that these are factors to breakdown of marriage. Hence, a decree for irretrievable breakdown of marriage can be granted in the above circumstances as seen to exist in the marriage. Period of separation, this is my suggestion, the period of separation will include the period. And it was pointed out to me by this court that in the UK they say the period has to exist prior to the filing of proceedings. But my suggestion is, well, the pendency of courts having regard to the enormous delays should also be taken into consideration. Another very common indicator of breakdown of marriage by initiated proceedings under 498A of the need to go to either party with libel, defamation against each other, other criminal proceedings for cheating, all of which lead to the conclusion that the marriage is broken down. All these indicators have been drawn from judgments of this court. Then, here, when I deal with the fault theory, it is true that some of the statutes in divorce contain provisions to the effect that it is to be satisfied that the party is not taking advantage of their own wrong. In section 23(1), it is submitted that the context of the husband either wanting a decree for restitution to defeat a claim of maintenance. In such a situation, it may be useful to look into the question whether the husband is taking advantage of his own wrong. However, in a hotly contested matter, seeking divorce on the ground of cruelty, desertion, adultery allegations are often page. This honorable court has held that by all this, and not an interesting observation. Give me Gura versus Gura. Interesting observation, my lord. Deciding to grant or not answers the question posed to me. Decree on the ground of breakdown of marriage not be blown out of proportion for in isolation and granting a decree for the cause of the ground of breakdown of marriage. Now, my lord, that judgment can be found at page 63 of. It is the only judgment, my lord, that I found which could aid in the interpretation of section 23. Again, this, but I won't take you through the facts because there were again multiple the allegations you will find at internal page 68. I mean, the allegations and counter allegations that they were having pornographic relationships with other people. Then, my lord, para 9 criminal proceedings were filed.
So then consent divorce filed, withdrawn. After that, consent withdrawn in the widow.
Yes, multiple petitions for divorce were filed. And then the indicators are at page 75, para 19. While considering the matter in detail, we find that the have not disputed the following. Marriage parties is dead and broken down. There were allegations and counter allegations between them. Also, sorts. And love is lost between them. There is a delay in the disposal of the matter. The husband has married again and has got a child. The wife has not withdrawn her consent lawfully given for a period of 18 months. The joint petition filed in the court by the parties that the parties have settled the matter and the wife had renounced her right to claim maintenance, which the parties prayed for was only a decree for definition of marriage by mutual consent. It appears that the appellate court was not come to court with clean hands. In that he married during the pendency of the proceedings. It may be, as expressed by the appellate court, that the factor such as marriage is dead and has broken down irretrievably, that there was no chance of reunion, that there were allegations and counter allegations made by the parties, and the parties were residing for 13 years. Each one of the above factors by itself individually may not have photographed. This is another legal formula below that they use. Each one is not sufficient, but cumulatively they are sufficient. Here at the view that the cumulative effect of various aspects of the case indisputably found that the marriage is dead, both emotionally and practically, and there is no chance at all of the same will survive. And a continuation of such relationship is only for namesake, and that no love is lost between the parties who have been fighting like Kilkenny cats. And there is a long. Just that, yeah, that. On the interpretation of 23, I would recommend para 23. Okay. Para 23. We cannot do, and we have not lost sight of the fact that the conduct of the husband is blameworthy in that he married a second time and got a child but that factor cannot be blown out of proportion. Similar, that answers, I hope, the question about section 23 that was posed to me. Then what do we do? We find that the party asking for divorce is at fault. Then, my lord, it is also important that before a decree is granted, an attempt should be made to reconcile. In view of the foregoing, the answers framed by this honorable court, as quoted here and above, may kindly be answered accordingly. However, it is submitted that before such a decree for divorce is granted on account of irretrievable breakdown of marriage, certain safeguards for the parties to the marriage, in particular the wife, are needed to be put in place.
Yes.
Sure, by this honorable court. A final attempt is made in reconciling. The determination is made that the marriage has been broken down, adequate financial provision, more particularly which is just, fair and equitable. Having regard, I will not please note that I've used the word equitable. Having regard to the various factors such as housing arrangements so the divorced wife and children, if any, financial arrangements consistent with the standard of living to which the husband is accustomed, welfare of the children, including the housing, education, provision, marriage, medical expenses, entertainment, extracurricular activities, custody of children where such custody is not mutually agreed in the best interest of the child. And no, this is the last one I've added based on Bhagat versus Bhagat. No blame is attributed to either party as a result of the decree for divorce, which may impact future civil or criminal proceedings. Now, this is just a checklist. Now, obviously, each one of them in the matrimonial law of other countries is very highly evolved, where the statute itself deals with financial provision. And I must point out, Milord, I'll be failing in my duty if I don't point out that England does have a regime of equitable distribution of matrimonial property on the breakdown of a marriage. We don't have it. More the reason why we should be careful in putting these safeguards in place while granting such a decree. A lot of attention will have to be paid to the fact by the judges that, now there are judgments of this court and of the Delhi High Court which cast the burden on the husband to disclose his financial status. And if I may say so, my lord, in the days when black money was very common, it was impossible for a woman to prove what is the real worth of her husband. There is so much hidden wealth in this country, it's unbelievable. But my lord, my information is that after demonetization, it has gone down a little bit. The existence of
I would not
untaxed money, but how much it still exists.
Technology and methodology today are available to get indexes which give us a better assessment of the income of the husband. Maybe returns, income tax returns, it may be other assets, ability to value those assets. Anything else?
Well, only one thing remains. I am keen on your lordships accepting the proposition that the right to marry and the concomitant analogous right to not to exit a marriage is a fundamental right. I would put it squarely under the right to life and liberty, read with the right to form associations. Well, at the end of the day, a marriage is an association. It is a right to affiliate.
When fundamental rights are subject to reasonable expectations.
It is, Lord. It's going to be, whether you like it or not, it's going to be a very major issue which is going to surface in this country. In a multiplicity of situations. Not that I'm arguing proxy for anything, but I need to let you know that there are petitions pending in the court where gay people have said we also have the right to marry because it's the right to affiliate. What the court will decide is not for me to say. But this is well traversed ground.
Can we step into those domains in these proceedings? Would be difficult to. I may have my own views in it, but if I step into those domains is a little difficult because then it would be really foreclosing the opportunity in those cases of this issue being debated. And
well, I am more interested in saying that right to divorce is a fundamental right. I am not asking you to address for the purposes of this case. For the purposes of this case, my lord, what we're looking at is there a right to divorce? What is the nature of that right?
See, there is no doubt there is a right to divorce. There is no doubt there is an enactment now for right to divorce in every position. Question is where there is a cause, and the cause may be by one person or both persons or other person. As long as people cannot live together, you are saying that they must have an opportunity to part ways and live their life.
Look, like all laws, it has to pass the test of reasonable restriction. If it's a fundamental right, then like all laws, it must pass the test of reason. If you unreasonably keep two people in a bad marriage, then, my lord, I'm sorry, the law is liable to be declared bad in law. That is why it's important to understand what exactly are we dealing with. We are dealing with intimate relationships. An intimate relationship, no decree of the court can force an intimate relationship. That I'm only arguing that you must keep that in mind. But I've got a few additional submissions. I'll finish quickly before we close for lunch. But they're already in writing. I've given a volume, and I won't take you through the literature on the subject, but there is literature. And the primary additional submission, just tell it. Ma'am, those additions. The primary one is, Lord, I'm just adding one more submission, and that is the right to marry a person of your choice is a fundamental right and guaranteed under 19(1)(c), read with Article 21. Equally, is the right to divorce must be considered a fundamental right, and no unreasonable restrictions can be put on it. It is submitted that the right should be protected under 19(1)(c). It is submitted that the right of association includes two rights: the right to form expressive associations such as unions, and the right to form intimate associations such as marriage and familial bonds. Then, there is this judgment of the Supreme Court in Roberts, which was a very interesting judgment. A club said we'll keep out women. And the law that was passed said that you can't keep out women. And in that case, they distinguished between intimate relationships and non-intimate relationships. So they said, all right, we can force somebody to become, to take a woman as a member in a club, because it's not an intimate association. But intimate associations stand on a different level. So only for that distinction between the two associations, the case is known as Roberts. It's there in the compilation.
Yes, you've given it a note on it in para 2 of your editions.
Para 2.
You already incorporated it.
That is on the well-traveled ground, well-traversed ground by this court on Puttaswamy. I'm sorry. Yes, there that the summary of Roberts submitted the United States Supreme Court in Roberts, where the constitutional validity of public accommodation laws was under challenge, held that the guarantee and the 14th Amendment of the United States Constitution protected, among other things, the right to marriage, childbirth, cohabitation, and with one's relatives. Such a right would also entail the freedom to leave such intimate association. This, I suppose, is my submission. This submitted that the right to form intimate associations is a part of the freedom of association and 19(1)(c) of the Constitution of India. The right to enter into association has an analogous right to leave in such an association without state interference. Now, this should be modified without, there is state interference in the form of the judge, the judiciary. So therefore, I would modify it and say reasonable restrictions can be imposed on the right, but not unreasonable restrictions. And to deny a divorce on the ground of irretrievable breakdown would amount to an unreasonable restriction than the right to leave a bad marriage. Then, Your Lordship may go through Roberts, the full text. I point that in this volume is also literature about how bad marriages impact children. That Your Lordship will find
Page
at page 31,
conflict and the damaging effect.
and how bad marriages are also bad for the two parties in question. There is an article on that as well. I mean, to me, it's common sense, but then academics want research, and that's why I'm giving you the research.
Thank you.
I'm here in my capacity as amicus, and therefore I can only persuade you. Beyond that, there's nothing I can do because I'm not representing a client.
Doesn't make a difference.
But
you are still persuasive enough.
I have to say that Your Lordship have given me the liberty to express my point of view, but in my capacity as amicus.
Thank you.
Well, there's no judgment of this court, incidentally, on what is the goal of an amicus. I haven't seen it. I've been looking for it high and low.
In one sentence to make us write better. Mr. Giri, you will begin at 2 o'clock?
Yes.
Obliged for application.
After Mr. Giri finishes, I'll take about 45 minutes.
How much time will you take?
Not more than 40 minutes.
Let's try to wind up today. Because
I'll convince myself.
I've scheduled other constitution benches immediately after reopening. So I would like to, I anticipated only about kept 1 day's cushion.
Read from the judgments, for the compilation.
Would give us some time also.
On what? See, divide your time. Both are saying. Ultimately, it will be repetition otherwise.
Correct, we'll not repeat.
All of you seem to be, I've not had a different point of view. All of you seem to be on this basis that in different ways, please exercise this power.
Yes.
But I am going to be
Opposite.
submitting to the point.
Oh.
The Lordships cannot exercise.
Oh. I'm glad my learned friend mentioned that.
No, it's at least that somebody puts a different point of view. Somebody has to put a different point of view, so we have the satisfaction of.
Because the way 142 has been used by this court, it's matter of.
No, the loose copy.
From income tax, for all kinds of matters, 142 is now being exercised. And that's a matter of great concern.
Probably on the argument about fundamental right to association and then fundamental right to get divorce, we may not be agreeable with the submission, But on the question framed, we would argue that yes, it can be exercised, it can be molded, it can be read into the enactment. Will be our submission.
If Mr. Dave,
I try to wind up not in 30-35
if you can wind up in
I'll just
30-35
make the
minutes,
points
and
for-
similarly, Mr. Dave, if you can make an endeavor to conclude.
Next.
I won't take.
I'm trying to persuade you to take 10 minutes less so that the others get it done.
I should have mentioned, just give me 2 minutes, delay your lunch by just 2 seconds. At 2019, page 1, just make a note of the judge. It is a case where the issue was whether voice sampling can be done.
Yes.
And one of the arguments was that this would go against the right to self-incrimination. The court rejected it. But what is important in support of my argument that it can be done under 151 is that this court actually said we can give this power to the court, to the magistrate court, para 22. That was done. So far as the second basis of the view taken is concerned, we have already expressed our opinion that what may appear to be legislative inaction, very important, but not in the light of Mr. Dave's submission. To find, no, because he's. I know you're yes, I'm glad there's a contrary point of view because I can counter it. Well, I stand because I'm not holding a brief.
Just give it.
Yeah, let's speak.
Serious inroad on Article 20. And it's completely contrary to.
Okay, thank you.
Well, I can tell you many judgments in this court, but they are judgments of the court.
You're not depriving us for lunch.
You don't tell me what to rely on, okay? What to rely on and what not to rely on. It's not your remit in this court.
Something apart from depriving us of earlier lunch, I have a meeting also of some concern to lawyers. We will get to sort out that problem.
So, just, your lordship will look at this judgment where there's an interesting discussion on whether this is legislation or not legislation.
We will read through the interest. Thank
Yes,
you.
please do because it can be done.
Thank you.